the bond in this matter to convert to a PR bond only to be released when a bed becomes available at Cedar Roots, which again, we believe to be June 15th. And then from there, we would be looking to get him into a sober living facility to help get him treated for his alcohol issues and get him started on this case and get him to a safer place, Your Honor. Trial services went over their criteria and they concluded the same, essentially that he would be good to be released as long as there's conditions. That is what we were asking for, Your Honor. Thank you.
On behalf of the people.
Yes, Your Honor. I've had a chance to talk to the victim in this case, Cynthia McClure, the defendant's brother or sister. I just want to clarify something that the defense had just mentioned. They stated that Mr. McClure has not had any criminal contact or any contact with the criminal system until the age of 61. I just want to point out in the pre-trial or in the bond form that I believe you should have received, the bond report.
I do have it.
Yes, it does state in the criminal history information that the defendant may have a multi-state criminal record for the state of Texas. I did have a chance, unfortunately, we did not have the multi-state criminal record for Texas. However, having a chance to talk to the victim in this case, it sounds like Mr. McClure has had criminal history in Texas, specifically a DUI and an assault and battery, Your Honor. So I just want to make sure that the court is aware of that, as that was not in the bond report. Additionally, Your Honor, I had a chance to talk to Ms. McClure, and she is absolutely terrified of the defendant in this case, Your Honor. She was in tears, sobbing yesterday at even the potential of Mr. McClure getting out at this point. That is because, Your Honor, he is apparently, prior to being arrested, made statements to her that he was going to kill her if he ever saw her again. So, Your Honor, there is a issue in the safety of others, specifically Ms. McClure, if the defendant is let out. Additionally, Your Honor, I understand he would be going to Cedar Roots, but after my conversation with Ms. McClure, she had informed me that he has actually attempted to go to rehab previously and walked out of that rehab facility, Your Honor. That was around 3 or 4 years ago. The people are concerned that if Mr. McClure is let out to Bear River, he would potentially be a flight risk again. Additionally, talking to her, she had informed me that the defendant had been making statements to her, as well as other people in her family, including a cousin, Sonia, who was also in our meeting yesterday, stating that the defendant has been planning to live off the grid for years, has been preparing to live off the grid. So, Your Honor, based off of those things, the people are concerned that the defendant is a flight risk in this case.
Is there an address for him? I have a Southbrook. What is that?
I believe that is the address that he cannot go back to at this time as a relation to this case.
Correct, Your Honor.
He has essentially lost his residence, well, at least temporarily, while this matter is going on. That's why, again, we have him set up to go to Cedar Roots and then to a sober living facility would follow that, as he needs to get started into some type of residential program as well, Your Honor, rather than just releasing him to the street. If he were to leave the rehab, he has nowhere to go. So he is very highly motivated to do that, Your Honor. This is an incident that's alleged to have occurred back in March. There have not been a single violation of bond from anything that I've been made aware of. No trying to call her from jail or anything along those lines, Your Honor. So that's why we're looking at trying to address the problems here, so that, if Ms. McClure feels uncomfortable, that maybe that won't be the case in the future once he's able to get through his treatment, Your Honor.
And have we had a pretrial on this?
That is today, Your Honor. There was an initial offer made that is being declined at this time. We do have a final pretrial date and a trial date.
When is the final pretrial?
Oh, I'm sorry, Your Honor. I have it in my thing and I'm supposed to give it to you.
Okay.
May I approach?
Wait. Sir, you're finally ready for treatment?
Ma'am, I have made an attempt in the past.
Okay, you made an attempt, but you didn't complete it according to what I was just told. So are you finally ready to complete and engage and commit to treatment?
Yes, ma'am.
If you don't, the jail or prison awaits.
Yes, ma'am.
I mean, there's no middle ground here. Do you understand?
Yes.
Okay. So here's what we're gonna do. I'm gonna give you a $50,000 PR bond upon transfer to Cedar Roots. You will be in the Cedar Roots long-term program. You're also going to have a jail GPS tether on. You can file for the indigency grant. I suspect you are eligible for that if they will not allow you to have it on at Cedar Roots for some weird reason. I don't run the place, but then upon exiting, you will then have the jail GPS tether, but I think they should allow you to do that. I'm not confident, based on your history, that you may complete it, and I also want the victims, your family apparently feels threatened by your past behavior, so we're gonna have the jail GPS tether so we know where you are. You shall not use, possess, consume, or be in the presence of illegal drugs, alcohol, or drug paraphernalia. If you have any prescriptions, you will show them all to pretrial services, Cedar Roots. Within 24 hours, you'll take any psychotropic meds as prescribed, you'll follow all doctor's recommendations. You will PBT and/or drug test as requested by pretrial services, law enforcement, any court officer, or Cedar Roots. You will not have in your possession or under control any weapon, gun, ammunition, or imitation of a weapon, or be in the presence of anyone who has those items. You will appear for all hearings and proceedings. The final pretrial date is 11 a.m. on September 2nd, 2026, and your trial is set for 9 a.m. October 2nd. You'll have no contact with Cynthia K. McLuth. Is there anybody else I need to include? Did you say Sonia?
Yes, Your Honor, I'm trying to
What's her
get,
last name?
I'm trying to get that right now. One moment, Your Honor.
And Sonia, we'll put down her last name in just a moment. And no contact means they don't exist in your world. No phone calls, messages through third parties, smoke signals, flowers, Hallmark cards, don't get creative. You will be released to Cedar Roots, the long-term program. You'll comply with everything, including the aftercare, and then you'll go to sober living. If there is no sober living available until it becomes available, you will return to the Ingham County Jail. I'm not gonna have you out there being homeless on tether and people be afraid. So hopefully we can put you from Cedar Roots doing the aftercare in a sober living environment. That makes sense to you, sir?
Yes, ma'am.
And you'll sign all releases so we can verify that you're doing what you need to do. Is there anything I failed to address on behalf of the people?
No, Your Honor, I will report, I do not have Sonia's last name, however, I will get that and give that
Just
to
a
the
moment.
court.
Sir, do you know who Sonia is?
Yes, ma'am.
Who is she?
She, technically a cousin, her father was adopted.
Okay, I don't care as long as there's family adoption or not, means
Yeah.
adoption is real family, so what, do you know what her last name is?
Alagna, Alaagna, ma'am.
I'm sorry, A-L,
Agna.
Alagna.
Yes, ma'am.
Okay, no contact with her or Cynthia. Is there anything else I can address? Do you think that's a problem, counsel?
I don't think that's a problem, Your Honor. I would just ask the court to seat the final pretrial date one last time.
The final pretrial date is 11 a.m. September 2nd, 2026, and the trial date is October 2nd, 9 a.m. And we'll get you a copy of this checklist in just a moment. You'll have all of that.
Thank you.
Is there anything else we need to address?
No, Your Honor, thank you.
Not from the defense, Your Honor. Thank
So,
you.
sir, I don't know when a bed's gonna become available, but you'll be released then only when there's a bed, and then they'll figure out transport. Transport will either be by Cedar Roots or the jail. You walk out of Cedar Roots, understand you may be walking to prison. It's up to you what kind of life you want, sir. Free man, being sober and productive, or incarcerated man, regretful. Choice is yours. It's all for the record.
Thank you, Your Honor.
Thank you.
Probably not, but I'm gonna talk to the staff to see that. So let her
I believe we're ready for the bond hearing on David Christian's files.
What's the last name?
David Christian.
Is there still the motion to quash this law?
No, that was already handled. That was the prior cases not being actually domestic victims that you actually.
Okay.
The parties came to an understanding about that a while ago.
Okay, I just have it as a motion to quash this bond on all.
Correct.
This is docket 26-707 FH and 26-701 FH. People of the state of Michigan versus David Lamont Christian, and then all matters. This is motion to reduce bond. The motion to quash has been resolved. I've noted that for the record. Counsel, your appearances for the record.
Good afternoon, Your Honor. Assistant Prosecuting Attorney Adam Pfeiffer on behalf of the people.
Good afternoon, Your Honor. Jacob Sarks, the fourth Assistant Public Defender here on behalf of Mr. Christian. Mr. Christian is present at the podium. He's standing to my right.
Thank you. I do have in my file a copy of the bond report. I assume both counsel have it. If not, I can make you a copy of mine. Sir, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes, Your Honor.
Thank you. Put your hand on. Are you taking any medication yesterday or today?
No, Your Honor.
Are you supposed to be on medication you're not on?
No, Your Honor.
Any sign of fever, COVID, or other illness?
No, Your
Have
Honor.
you had enough time to speak with your attorney?
Yes, Your Honor.
All right, on behalf of the defendant, what is your motion?
Thank you, Your Honor. Respectfully, at this time, and this is functionally a continuation of a bond motion that we had addressed previously, Your Honor, but I'm going to request a reduction right now in his current cash and surety amounts. He has a $100,000 bond on one file and a $50,000 bond on another file. Your Honor, he, prior to being convicted of a couple of PA 53s, Mr. Christian had posted a $10,000 cash and surety bond on one of his files. Respectfully, I would request the court consider granting him a reduction at this time, possibly reinstating the 10,000 bond that he had originally posted, and then a PR bond in the other file. The reasons for this, Your Honor, are very straightforward. He has kept his word to Your Honor. He has stayed away from contacting the complaining witness since his last court appearance. He has been very active, Your Honor, completing his classes as Your Honor wanted him to do. He's here with a bunch of certificates, Your Honor, ranging in letters and support from Daniel Waits. He has certificates of achievement from Case Credit Union, from the Breakout, from the Seeking Safety Program, Your Honor, from Parenting Time. He's been working very closely with Cats with CMH Your Honor, he has been doing everything that he can to try to improve himself. He received an excellent letter here noting that he has been participating in all his classes. By all counts, too, Your Honor, he has an excellent attendance record. And look, Your Honor, he made some pretty serious mistakes, which he has learned a lot from, Your Honor, but to his credit, he has shown, Mr. Christian has shown that he can learn from his previous decisions and make better choices. And also, he takes your words to heart, Your Honor. Since the last court date, he has been following your orders and following your instructions to him. If he is released, Your Honor, he has potentially a job lined up. He has a job with a good local reputable dealership. He was working for them prior to when he got picked up here. He has potentially a stable place to stay away from the complaining witness, Your Honor. He has, he's not a flight risk at all, Your Honor. We can put a tether on his ankle if Your Honor would prefer to have him on a GPS tether. That won't be a problem in terms of a GPS tether form. He is indigent, so he would need to request a indigent tether, Your Honor. So if you look in totality, Mr. Christian is an excellent candidate to be released to back out on bond now. He served his time on his PA 53, Your Honor. His out date is basically yesterday. And at this point, he has learned his lesson, Your Honor, from all this. I would note in terms of the charges and in terms of the bond report that we should correct that the domestic violence thirds, the 2 counts and 1 file, and then the 1 count and the other file, those are ultimately going to be reduced down to DV first, Your Honor. And that's going to be filed with an amended information that Mr. Pfeiffer intends to file. That was the issue with the motion to quash last time and would need to be updated in the court files respectfully, Your Honor. So we anticipate Mr. Pfeiffer's amended information will correct those issues.
So are you talking about 26701 FH that has the DV third should be a first?
Yeah, that's
Correct.
that's correct, Your Honor.
And then what about the 707? It has 2 counts of DV. Would that be a second?
No,
that's
those are
good.
each gonna be first.
They're all gonna be first?
Yeah. And the amended information should clear all that up, Your Honor.
Okay.
And just lastly, Your Honor, I would note that Mr. Christian does have support in the community for him. And if he is released, he'll certainly follow up with some additional community-based activities that he wants to participate in. So, Your Honor, respectfully, especially given he's been in custody now continuously since January 23rd, 2006, I respectfully request.
2006, you said?
Yes.
Okay.
January 23rd of 2006, or 26, excuse me, 2026. I respectfully request a reduction in his bond amounts.
Which one did he have the $10,000 in? Because I've got on the 701, he had 50,000 cash surety, and on the 707, 100,000 cash surety. You're asking me to reinstate which one? You know,
It was on, I think it was,
first file,
it
701?
was on the bond that he currently has 100,000 cash surety on,
Yes.
so that would be 701.
It was, no,
707 is
707.
It was 707.
So was that 10,000 cash?
It was, but then Mr. Christian was convicted of a PA 53 violation. Judge Ward increased his bonds up to 100,000 and 50,000 respectfully around the preliminary examination. I think it was during the preliminary examination date, if memory serves me, that his bonds were increased.
Thank you. Counsel?
Yes, and there is a correction that needs to be made in the bond report. That being that it states around talking about the PA 53 time that he served, that he was sentenced on 1/23. That is not correct. He was sentenced on the date of the examination, which was January 30th, 2026, to 93 days in jail and credit for 19 days by the district court. Which brings me to my other point. I'm pretty sure he still hasn't finished serving his contempt of court. Because from my calculations, from what Judge Ward ordered and sentenced him to back on January 30th of 2026, 93 days and 19 days credit, he finished his contempt of court from Judge Ward on April 14th, 2026, which is, I believe, 16th, 14th. 5 days after this court sentenced him to 93 days contempt of court, because he then kept making jail calls once he got up here. So by my calculations, he wouldn't start serving those 93 days until 5 days after April 9th, which means he wouldn't start serving it until April 14th. So 3 months would put us into July. So by my records, he still hasn't finished serving his contempt.
Well, Your Honor, according to the jail's records, he's eligible for a tether release now because he's been so active and participating in ways to earn good time and earn early release, Your Honor. So according to the jail's records, he's eligible for release on the 9th. That's correct. Yes. Thank you.
Okay,
I wasn't aware that earned early release was eligible for contempt of court. But that's not me saying that that's not true.
I
It's
don't
a
know,
legitimate lack of knowledge.
the jail's math is not our math,
Correct.
so,
But by my calculations here, he
Okay.
is not done until July 16th. That's a separate issue that would need to be figured out later today. But for the actual bond request here, initially, he had a $10,000 bond in file 707, and I believe it was a PR bond in 701.
okay,
Then, the date of the probable cause conference, the day after he posted his bond, I came to the district court and showed that he had been calling her pretty incessantly before he was released, after being arraigned, telling her not to come to court. His bond at the probable cause conference for file 707 was then increased to $100,000 cash surety, which means the bond that he had already posted was no longer sufficient. He was taken back into custody. At the preliminary examination, it was held through officer testimony under forfeiture by wrongdoing, because he had told the victim point blank, don't come to court. Don't testify, this will all go away. We then also have held PA 53 bond violation contempt of court hearings, because the defendant kept denying that he had ever contacted her. We did all of that. The cases were bound over, and he was found guilty of contempt of court and sentenced to 93 days with credit for 19 days served. It then came up here. And I want to try and make sure I emphasize this timeline. Within 24 hours of the case being bound over and being held in contempt of court, January 31st, 2026, he is calling her again, over and over, talking in detail about what happened at the preliminary examination, saying that, don't worry, just don't show, never, never, never show, never come. And they have to dismiss the case. And then he kept contacting her. I wasn't aware of any of that because I had other cases I was dealing with. The defense filed a bond motion at the defendant's request, and that's what spurred me to then go looking again, which is when I found hundreds more contacts. We got the detective involved, and then we had another PA 53 hearing here because he still refused to admit that he had ever contacted her, denied it to the bitter end, and then he was found guilty again of no contact order violations. Oh, and I should say, at the examination, after being found guilty of contempt of court, that's when the PR bond in file 701 was increased to $50,000. The bonds that he had that they're asking to reinstate were not sufficient for him to follow the orders of the court and not commit further felonies on reported lines. Then, when he had a $100,000 bond, that was not sufficient for him to stop violating the orders of the court and not commit new felonies on reported lines. Then, when it was $150,000 across the two, that was not sufficient for this defendant to stop violating the orders of the court and committing new felonies on reported lines. I do not believe that if his bond is lowered, he will not continue to do so. I do not believe that when he's no longer on reported lines, he will refrain from contacting her. Now, I do not have evidence of any further contacts since he was found in contempt of court by this court and he had numerous privileges revoked. I'm not saying they don't exist. What I'm saying is I have been busy. I did a cursory view this morning through his contacts, as well as what smattering of his video visits and jail calls. There was nothing that I saw to indicate that he was in contact with the victim anymore. But what it did indicate is that he still believes this case is required to be dismissed if she doesn't come to court.
was there a preliminary exam at either either case or both?
Yes, they were done with the officers through the forfeiture by wrongdoing. Because he told her, including the day before, don't come to court. And she complied with what he told her to do. He then again, after that said, for the further hearings, which would be a trial, don't ever come to court. Don't come, never, never, never.
But did she testify during the preliminary
No.
hearings?
She did what he told her to do, which is don't come, don't testify. I still anticipate that if she does not come to the trial, I will be doing this trial victimless because he told her don't come. He is grossly mistaken about what he believes the law is, but the fact that he still believes that we are required to dismiss this case if she doesn't come to court indicates to me that's still his goal. So for all of these reasons, I'd ask that you deny the motion to reduce the bonds.
Thank you. Response?
Thank you, Your Honor. This is about bond. We potentially are going to have an extended period before his next court date after today. Your Honor gave him some very good advice at our last hearing. Mr. Christian has been faithfully complying with Your Honor's advice. He's been so involved with the jail. He's been doing such an excellent job of participating in all these classes, Your Honor. And respectfully, I request a reduction at this time. Thank you.
Sir, without talking about the offenses, what would you like me to know?
I would just like to say that, you know, I have made mistakes in my past. I can't change that. Moving forward today, my word, I ask you for a second chance. That's something that I can prove to you and myself. I pray to God to let him know that, like, I know I gotta take responsibilities for my actions. My past is my past. I'm looking for the future. I'm looking to show the course, show Mr. Piper that, hey, you tell me to stay away, I stay away. You tell me to let me get a second chance, that's all I need, is a second chance. I wanna get out and be with my family, spend time with my mother, you know, stuff like that. And I'm following everything that I can, and I will not break I will not break my promise.
Break your promise.
Thank you.
Do you have children with her?
Yes, sir. Yes, ma'am.
How old are they?
I got a 24-year-old and a 26-year-old.
Do they're adults?
Huh?
They're adults.
Yes, ma'am. And I got a granddaughter that's 4. And I'm always in their life, you know. I'm making mistakes. I can't take that back. But I can put to rest to show better as a man.
Sir, these aren't just mistakes. We have unlawful imprisonment, a 15-year felony. These are allegations, but for bond, I have to consider safety of the public and safety of the victim. And these are not just tiny blips. It's not like a mathematical error. We have unlawful imprisonment, assault with intent to do great bodily harm less than murder by strangulation, a 10-year felony. Domestic violence, I guess that's gonna be reduced to a 1 year, it's a 93-day misdemeanor. Another domestic violence, a 93-day misdemeanor. Bribing, intimidating, interfering in the case, which is 10 years. And there's an habitual 4th offense notice with a mandatory 25-year sentence, which means that your 15-year goes up to life, the mandatory 25. That's staying intact, is that correct?
That is correct. And to be clear, the other felonies are also life offenses, including the witness bribery that is made by hitting play on his jail call. That's a life offense because of his history.
And then we have on the other file, interfering with electronic communications, a 2-year felony. Domestic violence, a 93-day, apparently it's being reduced to a 1st. Bribing, interfering, a 10-year felony. Again, habitual 4th, punishable by life. We have life offenses. These are not just minor blips. These are problems, sir. And twice you've been held in contempt. I have no confidence to believe that suddenly you are going to change your ways.
I'm gonna still seek help. I'm gonna go out, seek help, stay with my counselor, rehabilitate myself with my programs, and that's what I'm gonna do, and stay working. All I need is a second chance, Shauna.
Well, this would be a second chance. This should be more like a 3rd or 4th chance. Or if you look at the habituals, it might be a 5th, 6th, 7th, or 8th chance. I don't know. You are charged with violent offenses. It is not recommended that you be released on your own recognizance after looking at all of this. And you have 2 or more prior qualifying failure to appears.
Your Honor, yeah, Mr. Christian has reviewed the history and would respectfully disagree with that. To the best of Mr. Christian's recollections, he's always made his court dates. Thank you.
There have been 5 different bench warrants issued for him in the criminal history listed here alone.
I was on prison.
But part of that was due to where he was locked up, Your Honor. He was in prison when a lot of his court dates went out. We're talking district court cases. If you review the history, and certainly that is something that's not unusual where a person's lodged at different facilities, especially if they're in MDOC custody, and if a district court isn't aware that a person's in prison, that these types of situations can occur. And for that matter, I practiced out in Kent County for over a decade, and that was not an unusual result either. If a person got sent away and if they were in an MDOC facility, especially with the 61st District Court, Your Honor.
3 of them were before he was in prison.
What is if the victim decides, for whatever reason, she doesn't want to show up, what is the likelihood of success on behalf of the people on either or both files?
Very high, effectively guaranteed on the witness interference because he said point blank, don't come to court, so this will get dismissed. On the rest of the charges, also fairly high, because when jurors hear you say, don't come to court, and the victim still says on the call that what happened is the truth, what she told the cops happened that day is the truth, they tend to believe those statements. I would be going forward under forfeiture by wrongdoing because he made it to where the victim's presence is no longer legally required to convict him.
Motion denied. Bond will stay as it is. Thank you.
Thank you,
Thank you,
Your
Your
Honor.
Honor.
Next matter.
Letitia Wells. Yeah, 11:45, I believe.
Who's gonna prepare the order? Do we need one? Just give me one, fill out one of those ones, I'll sign it. It says denied. I don't know if we need one. Sure.
Wells.
I'm sorry, Mr.
Letitia Wells.
Yeah. Thank you.
Switch places, please. This is docket 21898 FH, People State of Michigan versus Letitia Monica-Marie Wells. Counsel, your appearances for the record.
Good afternoon, Your Honor. APA Barb Buxton on behalf of the people of the state of Michigan.
Erin Robinson, Assistant Public Defender for Ms. Wells.
I believe I already arraigned her counsel. Ma'am, please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth, and no perjury? Here, put your hand down. You were here a couple of days ago and I arraigned you, just so we make a record of what it is specifically. There's a bench warrant, you were picked up. I signed this bench warrant December 20th, 2021. And it says you should be held in contempt for the following reasons. You tested positive on November 22nd, 2021 for methamphetamine. You failed to drug test and alcohol test on November 29th, 2021, December 11, and December 13, 2021. And I assume, although I don't know, it should be at any time thereafter because you failed to appear, but nonetheless, then count 2 would be defendant failed to appear to pretrial services since on or about December 16th, 2021, and any time thereafter. Do you recall that?
Yes, ma'am.
And then we appointed you an attorney, and I believe I read her rights of arraignment, or are you waiting for an arraignment?
Yes, Your
Have
Honor.
you had an opportunity to speak with her?
I had.
Ma'am, have you taken any medication yesterday or today?
Suboxone.
Does that interfere with your ability to understand your attorney or this court?
No.
Is there medication you're supposed to be on that you're not on?
No.
Any sign of fever, COVID, or other illness?
No.
And is she going to plead today?
She is pleading to the bond violation.
Is that what you're doing, ma'am?
Yes, ma'am.
Of your own free will?
Yes, ma'am.
Anyone force, threaten, or coerce you or promise you anything we haven't made a record of?
No, ma'am.
You decided to plead after talking with your attorney?
Yes, ma'am.
And you're satisfied with the representation of your attorney?
Yes, ma'am.
As to testing positive on November 22nd, 29th, 11th, I'm sorry, as to testing positive on November 22nd and then failing to appear on November 29th, December 11th, and December 13th, and you failed to appear for the drug or alcohol test, and on the 22nd, testing for methamphetamine. How do you plead?
Guilty.
And then as to failure to appear to pretrial services since on or about December 16, 2021, and any time thereafter, how do you plead?
Guilty.
Ma'am, you understood the terms and conditions of probation, and they were bond conditions, or not probation, but bond conditions. You were released on a bond, and you were told to check in with pretrial services, drug test, not violate the law, and appear for all hearings and proceedings, and you failed to do all of that. Is that correct?
Yes, ma'am.
And there was nothing preventing you, like incarceration or hospitalization. Is that correct?
No.
No,
Well, yeah,
there was
yeah.
nothing. All right. I find defendant's plea has been freely, voluntarily, knowingly, and understanding made of her own free will. She's acknowledged that. She also acknowledged she understood the terms and conditions of bond conditions and violated them. Therefore, she is held in contempt for violating bond conditions. We haven't seen since 2026. We haven't seen her since 2021. On behalf of the people, what are you requesting?
Your Honor, the people will be requesting at this time a $5,000 cash surety bond. The people are concerned that Ms. Wells, if let out, is going to fail to appear again. Ms. Wells has now been gone, as you would say, for a little under 5 years at this point. And not only that, Your Honor, but was testing positive for methamphetamine. The people are concerned that if she is let out, not only is she going to be a flight risk, but she's potentially going to be a danger to herself, Your Honor. So I believe at the very least, a $5,000 cash surety bond would be appropriate.
And has a pretrial been held in this or not?
Your Honor, I did give a pretrial form to the defense. I'm not sure if that was submitted or not yet, but.
It's in my bag. I just haven't signed it because I
Okay.
forgot about it.
No problem.
But I was just appointed yesterday, Judge, so I still haven't had a chance to review all of the discovery and everything in this case. But
Okay.
after, briefly looking over everything, I think this is gonna be a case that we can resolve pretty quickly.
Okay. In regard to bond,
Yes, Your Honor, we would ask that you allow her to PR to treatment. I did speak with Ms. Wells. She is open to doing treatment, and since coming into jail, she's been put on Suboxone. And this is really, the first time in her life in a long time that she's given the chance to get clean and the ability to stay clean. And she has told me that she has a desire to stay sober and wants to stay sober and is willing to avail herself to those requirements. During negotiations with the prosecutor, we have been talking about treatment options for Ms. Wells, so it's likely that she would have to do something with treatment as part of her plea if she does decide to plea. And she's willing to do that now, and she wants to get the help now. So we would ask, Your Honor, to hold her until a bed is available at a treatment facility.
ma'am, what would you like me to know?
I just really would like to be able to turn my life around. I know before I wasn't ready, and I know now I am.
How old are you, ma'am?
I'm 43.
Have you looked in the mirror?
Mhm.
What do you see?
I'm just really ashamed of myself. I have three kids and 4 grandbabies, and I'm not allowed to be around them because of my addiction.
How old are your kids?
26, 23, and 19. And
Are they with their dad or what?
no, they're all on their own. They have their own place and stuff, and just I don't lie to my kids, so they know that with addiction. So I just haven't been able to be around them.
Well, their tough love will hopefully save your life. Man, you don't look like you're in your 40s, you look like you're in your 60s or 70s.
And
The drugs are killing you from the inside out. You look thin, pale, frail, and that's not from the jail, that is from drug use. Your abuse is killing you. The legacy you're gonna leave to your children is that you loved your drugs and not them. Is that what you want?
no,
Well, then you've got to choose to love yourself and your children more than your drugs.
you know,
You are like the walking dead. Choose to be clean and free of drugs and live. It's amazing when I see people off drugs, it's like having a facelift immediately.
right.
I don't know why you got addicted, or what you wanted to check out from, but you need a lot of therapy to figure it out. I suspect there's a lot in your background that you can't deal with. Asking for help is a sign of strength and a willingness, a desire to get clean, and that's where you need to be before I release you. So it's going to be a $25,000 cash bond. After resolution, whether it be by jury or plea, I will consider I can do it, I'm gonna do it now in bond conditions. She might need it, but I think she needs to be clean for a while, get her head straight a little bit more, and then go to treatment. We're gonna give her whatever treatment we can in the jail in the meanwhile. Community mental health should see her along with medical. I think they're probably already dealing with you because you're on this Suboxone, but man, you've got a lot to deal with. So before I send you over, it'll probably be TRICAP, I believe they're meth. There's a better agency for meth. You need to go to a meth-specific long-term treatment. And you need to do a lot of counseling. So before I do that, I would like to see this case resolved, and then one of the things that I will do, as long as things continue to go in the right direction while you're incarcerated, there's no criminal activity, no making drugs in jail, that does happen, we see lots of things. As long as you're doing well, then I will consider putting you in TRICAP and probation and doing all of that with, obviously with the punishment being going to prison to save your life. So you have to decide if you want treatment or prison. I don't know what your guidelines are, but, I don't know if she's eligible for 7411. I don't know anything about your case, ma'am. The attorneys are gonna talk about it. And I'll see you here for plea or trial. Maybe it'll get dismissed, but it doesn't sound like that. It really sounds like you need some serious treatment to save your life, so you can spend the rest of your life getting healthy and with your kids, who will learn to respect that you got clean and that you love them instead of your drugs. Do your grandchildren even know they have a grandmother?
Yes.
Be fortunate they were told that. Because if you would have been my mother, I would have just said, I don't know where she is. I wouldn't have even owned what you're doing to my grandkids. Because my children. Because you're not deserving of that right now. If you want it, you will earn the trust, and you will earn being with them. It's not a given that you're gonna be with them, do you understand? Okay, so 25,000 cash bond, she would be released on tether. I doubt she can make it, so I don't think I need to do anything further. I would like to see what's the date of the pretrial or final, we'll do a continued pretrial, final pretrial.
Your Honor, unfortunately, I didn't write it down. It's on that pre-trial sheet.
I can grab it real quick.
Attorney Robinson can get that.
So certainly if she's doing well and we need to get her into treatment sooner, we can move the dates up. I'm not locked into those dates if we can get her into treatment and there's some kind of resolution, but I'm not doing it now.
And Your Honor, I know I did get pretty quick court dates in regards to.
Good.
It looks like the final pretrial is scheduled for August 5th at 11, and then the jury trial is August 28th. But hopefully, I think we can probably come to a resolution sooner than that. If you'd like, I can contact your staff to get
That'd
a
be
date.
great. As long as you all work out if you're gonna work out a plea sooner than later, I've got time on my schedule, so we can, get her in, but I'm not doing anything without that. There needs to be-
Absolutely, Judge. I'll contact your staff as soon as we have something available.
Ma'am, I need your commitment to sobriety, treatment, and all of that, and then if you plead and things don't go well, it may very well be prison. I don't know that jail time will be enough for what you got. This is a long time problem. So, work hard, get healthy, get real honest with yourself and your therapist, and this will get better, I promise you.
Thank you.
I'd like to.
Judge, we have jail credit days.
How many, well, she's not, how many jail days does she have?
How long, when did you go in? When were you arrested? Do you remember?
22nd.
22nd of May.
22nd of May?
So 9 plus 19.
I think it's 20.
19 or 20 if we're counting today or not, yeah.
Yeah, it has to count today, so 20 days. Credit so far, but it's not, I'm not releasing her, so I'll hope that those will continue to accrue. All right, thank you. See you soon. Actually, let me go back on the record on that for a minute. I'm just gonna say, because I found her in contempt, I'm just gonna say 93 days contempt credit for 20, and within those 93 days, we're going to have both the pretrial and the final pretrial. That will make sure we keep us moving. How's that?
Okay.
Great.
And we can readdress that.
And you
if-
can readdress the time frame
Understood.
to get quicker, because I do think she needs to go into immediate treatment. It's just not happening today.
I understand, Judge.
All right,
Thank you.
I think that's a better resolution. Thank you.
I still got bonds.
She still has to pay that at the end of the 93, just in case. We can't lose sight of it. We gotta make sure she is treated. Okay.
Just hold on, I'm gonna get it.
Oh, who's next? We're almost done.
Yes. Who's the criminal?
We have one more that we need to clear the courtroom for.
That's what I figured.
All right, for those of you waiting, we'll meet with you soon. We have to do a non-public one. you mean? Did you talk to his?
There was a pre-trial, Your Honor. We do have a plea date that's gonna be set. I do not have that date. But Attorney Kaplan got that plea date.
You just let us get to.
What's our next one? Well,
Mr. Joyner, you're free to go. Yes, you're good to go.
Your attorney's gonna contact you with the date, okay? Now we have civil. I don't know what that is.
Yes, all done.
you sure?
Criminal, yes.
Coming back today, are you?
No, as far as I know.
Mr. Buxton, don't forget about, Wilson.
Yes, correct. Correct.
Thank God.
Yeah, I believe so. You guys have a good rest of your day.
You too.
Perfect, thank you.
Do we know if we're doing that or not yet?
Yes.
Do you have a response? All right, this is, wait, ready?
No, what are we doing?
Doing.
412 and I.
Lavelle. Lavelle?
Okay.
This is Stephanie Lavelle, personal representative of the estate of Bradley Lavelle versus Michael Patrick Mullen, Ryder Truck Rental Inc. and Ryder Integrated Logistics Inc. Counsel, your appearances for the record.
Good afternoon, Your Honor. May it please the court, Attorney Al Smith, P86500, on behalf of the plaintiff. Good afternoon, Your Honor. Mr. Selecki, P84962, here on behalf of defendants.
Thank you.
And good, Your Honor, good afternoon. This is Mark Lipton, also co-counsel for plaintiff. I'm, as you can see, out of the state at the moment, but I did ask to appear by Zoom to assist my associate if there's any issues that need to be addressed.
All right, thank you very much. Appreciate you jumping in. I didn't see you. Thanks. Welcome, sir. All
Thank you, Your
right.
Honor.
This is defendant's motion in limine to admit into evidence that plaintiff decedent was riding his motorcycle in excess of the posted speed limit at the time of the subject accident, which is a violation of MCL 257.611. Counsel, you may proceed at the podium, please.
Your Honor, this motion in limine is actually kind of simple, more than it's been made out to be. There are numerous experts and the arresting officer, or the, not arresting officer, but the officer on the scene. There's no contention and there's no evidence to support that the decedent was driving at or below the 45 posted mile-an-hour speed limit. The reason we had filed this motion in limine is because we want to avoid essentially a trial within a trial where plaintiff attempts to move that the 45 mile per hour speed limit was unlawful or for whatever reason didn't apply in the instance. It's a pretty black and white issue in my mind, at least, that there's no evidence to suggest that he was going at or below the speed limit. Every expert or the officer all had him higher than the 45 miles per hour posted speed limit, and where the accident occurred, the speed limit is 45 miles per hour. MCL 257.611 is essentially just you have to obey the street signs and the posted speed limit, with a single exception, which would be under the direction of a police officer, which was not present in this matter. Essentially, what we're asking for is affirming that the decedent was traveling at speeds in excess of the posted speed limit, striking and excluding all opinions criticizing or challenging the propriety of the posted speed limit, and 3, prohibiting plaintiff from referencing, arguing, or implying that the posted speed limit was incorrect or unreasonable before the jury.
Was posted speed limit was what?
Sorry.
I had it and then I lost it.
Let me get back to
You
it.
said unreasonable or
It was incorrect or unreasonable before the jury. Apologize.
Thank you.
Yeah, you're gonna break the speed limit here, you gotta slow down a little bit.
Apologize, Your Honor. But essentially that's what we're trying to ask, is we don't want to have a trial within a trial where we're essentially arguing whether or not this 45-mile-per-hour posted speed limit was reasonable or not. It was what the speed limit was at the time. It's what everyone has to follow. And it's an argument that I've seen people try to make when they get out of a speeding ticket, and it's rarely successful, so.
Thank you. Response?
Yes, Your Honor. Thank you. I will try my best to keep it very brief. Defendant's motion is a little interesting because what it tries to do is make this case about the speed that plaintiff was going at the time of the accident. Defendants want a finding that plaintiff's speed caused the accident is requesting the court do something that it cannot do. The plaintiff had the right of way, the defendant rolled the stop sign. Those are the facts of this case. The court should deny the request for an order finding that plaintiff was speeding. The first, this one fact in isolation does not answer the question of whether or not the plaintiff was negligent. It doesn't answer the question of whether or not the plaintiff failed to act with reasonable care. And it doesn't answer the question of whether or not the plaintiff was comparatively negligent.
Let me just ask you something.
Yes.
Do you all agree, based on the expert studies that were done, that he was traveling between 50 to 55 miles an hour before he crashed, which would be about 5 to 10 miles over? Is there any dispute in that?
No, the testimony does indicate that at that location where the accident happened on MLK Boulevard and Olds Avenue, that traffic at that time of day, that travelers will go 5 to 10 miles over the posted speed limit. So the speed limit, we're not making an issue about it. We're not arguing that the speed limit was the posted speed limit was illegal, and it's irrelevant, and we're not going to be introducing that evidence for purposes of the trial. However, what the defendant wants to do is have the court issue an order that the plaintiff was speeding, to say that that is negligence per se. And as you are aware, because you read the.
Yeah, wait, let me just stop you there. Is that what you're doing? You want to say it's negligence per se? Because I'm not going to do that. If there's an agreement, there's a way to handle this. If there's an agreement that he was going with the flow of traffic, we've all done it. Let's be honest, everyone in this courtroom who drives has gone with the flow. Sometimes it's 10 under and sometimes it's 10 over. And if we go slower, we're gonna get smacked in the rear end and we don't like it, but that's the way it is, right? And so maybe that's what happened here. I think every juror can probably relate to that. But to say that that caused the accident is not appropriate. So you can't have it both ways. What specifically are you asking for so we don't get into the weeds?
Your Honor, it's how I said, we don't want to have any testimony brought in that it's typical for people to be driving 55 miles per hour. We just want it to be very clear that the speed limit was 45 miles per hour and that plaintiff was driving in excess of that, or decedent was just driving in excess of that.
Well, but would you agree that there could be testimony that the experts have shown that all the traffic or the traffic around that time was traveling at that rate of speed? So that does not mean that he was necessarily negligent and that caused the accident, because that's really the issue as I see it. And I don't know much about this case compared to what all of you know, but the speed may or may not have contributed, but the fact that he was going faster does not have an immediate conclusion that he was at fault.
Your Honor, may I speak?
Yes.
May I speak, Your Honor?
Sure.
Thank you, Your
Yes.
Honor. Let me see if I can help the court conceptualize this issue. First of all, what Mr. Smith said is 100% right. We do not intend to introduce any argument about whether the posted speed limit was correct with the traffic control order. In fact, we would stipulate and ask the court to enter one order tonight, and that is an order precluding any testimony from Mr. Robbins on that issue, any cross-examination raising that
You gotta
issue.
slow down, sir. We're on Zoom. and it's, your words are getting jumbled together. My court reporter is gonna jump up and say, see you next week, okay?
Got it. I'll go slow. Sorry. We would stipulate to an order that says that Mr. Robinson will not testify about the lawfulness or correctness of the post speed limit sign. We would agree that that should be, mutual. Defendants should not be able to ask Mr. Robbins about that opinion, which came out of his deposition. It's not relevant to the issues. So let's put that to the side. On the issue of the order requesting that well, actually, let me address what defense counsel just said. Defense counsel said they don't want any testimony or evidence about whether traffic ordinarily travels in excess of the speed limit at that location. But of course, that is not correct, because the issue under the jury instruction is whether Mr. LaBelle was negligent, whether he failed to use due care. And testimony that excuses his violation of a statute is always relevant to whether that violation itself was negligent. So the testimony of the officers that in fact Mr. LaBelle's speed at 55 miles an hour was nothing out of the ordinary goes to whether or not he acted with reasonable care. The problem with defendant's motion then is that they are asking the court to have a ruling or an order that raises one fact in the case that itself it's not a conclusion of law. It's one fact in the case. And if the court were to do that, it would have to instruct the jury of the full circumstances of the case. It would have to say something like, ladies and gentlemen, it is agreed the plaintiff was traveling at least 55 miles an hour. However, there is testimony that that is reasonable. It is for you to decide if the testimony was, or if the plaintiff was acting without due care. And the court would then have to instruct the jury that the defendant, which is on video, rolled through a stop sign in violation of a statute. And again, that's a fact that, the jury's going to hear the evidence in this case. The court shouldn't be in the business of picking one fact out and raising its salience, because my concern is not that the jury is going to hear, because they're certainly going to hear about my client's speed. But my concern is that the jury is going to hear something coming from the judge, from the bench, and give it undue weight as to the issue in the case. Now, at the close of the trial, I can tell the court that we're going to move for a directed verdict on the issue of one defendant's, the driver's, negligence, because there will be no evidence to suggest or from which a jury could conclude that rolling through a stop sign without any reasonable excuse is negligent. That's negligence. But after all the proofs come in and the court's heard all the evidence, we will make that motion. But today, the court, I think you understand my concern about raising, just, ladies and gentlemen, I'm ordering you to understand that this man was going in excess of the speed limit. That's just, like I said, I think it's prejudicial. I think that is, it's not really relevant because it doesn't answer the question that the jury needs to answer, which is, did the plaintiff act with reasonable care or failed to act with reasonable care such that he was negligent by, in fact, going faster than the speed limit. So I think the motion's not well placed today. I hope I didn't go too fast for the court reporter. It's really a struggle, as the court's going to see. But I think that addresses the entirety of the motion. I think the only order today should concern this issue of, is the speed limit itself lawful or not? We're not going to go there. But whether it was reasonable or not for Mr. LaBelle to exceed the speed limit is clearly a question for which there will be evidence, and it is a question for the jury to determine. Does that make sense to Your Honor?
Oh, it makes sense. I think the issue is going to be, I mean, I would agree it should be with the jury, but I think the question is going to be, because he was speeding, does that absolutely infer that he was somehow negligent? The answer has to be no. It has to be a totality of all the circumstances. And I think that and maybe what we need to do is, I deny this, but we look at the jury instructions and maybe alter them after the evidence comes in, so there's a clear understanding that just because you're speeding does not equate negligence. They have to look at the totality of the circumstances, and maybe that's a better fit.
Yeah, and Your Honor, there's aside from the comparative negligence instruction, there is an instruction on violation of a statute. It's a standard instruction, and it talks about it can be evidence of negligence. In our response brief, we cited, I think it's the Zeni case, Zeni, that specifically says violating a speed limit is not negligence per se, just for the reasons the court said. So again, I just, aside from the one discrete issue, I think that the rest of this motion should be denied.
Thank you.
Sure, if I may, and I just to make sure I keep the record clear on this one too, it seems to me that everything that we requested, there hasn't been any contention that he was operating over the speed limit, and I know that 55 miles per hour was the amount said. I just want to correct that was the minimum above the speed limit. We have our own expert that says that it was higher than that, but just so that's clear, and that I haven't heard any contention with the three requests that we had asked for, that he was. There's no evidence to suggest he wasn't going over the speed limit, and I would disagree a little bit with the interpretation of the Zeni hearing, but I won't waste more of this court's time.
Thank you. Counsel, anything further?
Nothing further on my part, Your Honor.
I'm going to deny this. However, I am going to say that let's visit this at the time we get to trial, if we get to trial, and then perhaps look at some kind of instruction, or I hold you to what you've told me today in terms of your questioning, so that it's not inferring something that is in fact not true and goes against the expert opinions. So I think that counsel who has heard the experts' opinions and understands the parameters we're dealing with can fashion this in a way that is not interpreted incorrectly, so that we get a verdict that we shouldn't get from the jury.
Your Honor, can we get that? Can we get an order granting the one part of his relief that we don't disagree with, that says that both sides will keep this testimony of the improper speed limit because there's no traffic control order? Let's just keep that out of the case. I think that's just confusing. It's confusing the issues. It's irrelevant. It was a posted sign. My client wouldn't have had any idea of whether there was or was not a proper control order there. And I'm not going to raise it, and I just don't want it to be coming up on cross-examination. I think it's just a waste and irrelevant. And since it was the relief, one of the reliefs that they requested, I think that we should have an order on that one discrete point.
Is there agreement?
As of now, Your Honor, we're fine with that, yeah.
All right. Who'd like to draft the order?
I'll draft something up and we'll spin it around. I'll take care of it.
All right, thank you. Anything else? And are you within the confines of the scheduling order in terms of everything else we have to do here to get us to trial?
I believe so.
Your Honor, we are
All right.
ready for trial. We are ready for trial. We've got that as a date certain, as I understand it. I know when we said it, we've got 3 lawyers that have moved their schedules around. So I fully want to go forward with it on that date. And I really hope that works for the court.
I don't remember what day it is, but probably is
Like mid-October.
probably a good day.
Thank you, Your Honor.
I don't know why it wouldn't be, but things happen around here that are way out of my control. But anyway,
I saw that
sure.
this morning.
Yeah, obviously, yeah, thank you. So thank you all for your cooperation, your input, and I'll look for that order. Thank you.
Thank you, Your Honor. Nice to see you again. And I appreciate your indulgence with this Zoom thing.
It's a way of life now since COVID, and actually I think it's a good thing. So thank you.
I love it. And like I said, I'm on the West Coast right now for work. I missed my morning conference all morning waiting for this, and then I'm taking a little vacation. So take care, Your Honor.
Enjoy vacation. Thanks. Bye-bye. All right, next. I don't know what the next one is.
I only grabbed like half the file here because it's a very massive file.
All right, well, what case is it?
Stockbridge Civic Cell. Yeah, there's like a third of it.
All right, this is docket 20262 NO Joel Stockford versus Chrisman Company, Sodexo Magic LLC, and Christmas Company versus Shaw Winkler Inc., Sodexo Magic LLC. Cross defendant. All right, counsel, your appearances for the record. Nice to see you all
Nice to see you,
again.
Judge.
It's
Johnny.
becoming a regular thing.
Right, Johnny for the plaintiff.
Ben Dilly here, Your Honor, on behalf of the Christmas Company.
Good afternoon, Katie Kennedy on behalf of Shaw Winkler.
Michael Bryant on behalf of Sodexo Magic, and Tim Smith spoke to me. He has been
He
here
is.
most of the afternoon.
He's on Zoom.
Okay.
Yeah, sorry for the delay. Okay, thank you. And this is defendant Shaw Winkler's motion for summary disposition, correct?
Correct, 2 motions for summary disposition as well as a motion to adjourn.
Thank you. You receive.
Your Honor, I have a preference on which motion for summary I start with.
Whatever you like. Thank you.
We'll start with the motion for summary disposition on the 3rd amended complaint. The 3rd amended complaint? Yes. This motion, Your Honor, presents one legal question to the court, and that is, did Shaw Winkler owe plaintiff a duty with respect to the unguarded air handling unit? The answer to that question is no. This motion was properly granted the last time it was presented to the court. The factual basis for that decision has remained unchanged. There has been no change in the law to have altered that decision. There are several facts that are not in dispute. Shaw Winkler was not the general contractor for the project. That was Chrisman. Chrisman was responsible for coordinating the work and the supervising of the subcontractors. Plaintiff was not employed by Shaw Winkler. Plaintiff was employed by Lake State Installation. Shaw Winkler never performed work on the air handling unit. And the missing guard from the air handling unit was missing long before this project began, and therefore before Shaw Winkler arrived to the property. Now, Fultz, F-U-L-T-Z, and Lowecki, L-O-W-E-K-E, are cases that mandate that to proceed with a claim, plaintiff must establish a common law duty owed that is separate and distinct from any duty that Shaw Winkler might owe under its contract. Under those line of cases, the courts have held that this occurs where a party's own conduct creates a new hazard or causes an unreasonable danger. Now, those are the key words: conduct, create, and cause. Now, it's important to know plaintiff does agree with this. Throughout plaintiff's response, they argued that this is the proper framework. They've relied heavily on Lowecki. Plaintiff's own response states that the issue is whether Shaw Winkler's affirmative conduct created an unreasonable danger. And again, those keywords, conduct and create. The problem for plaintiff is that there is no evidence of any affirmative conduct with respect to the air handling unit on the part of Shaw Winkler. There's no evidence that Shaw Winkler removed the guard. There's no evidence that Shaw Winkler touched it, repaired it, modified it. There's no evidence that Shaw Winkler took any duties with respect to this air handling unit at all whatsoever. And without evidence of this affirmative conduct that created or caused the hazard at issue here, there is no duty owed to plaintiff by Shaw Winkler. Now, there's a Michigan Supreme Court case that is directly on point here and is dispositive. It is the Hill v. Sears Roebuck. That's at 492 Mich. 651. It's a 2012 case. In that case, the appliance installers entered a home to install an electric dryer and a washing machine. In the room where they were installing the dryer, there was an uncapped gas line. It existed before they got there. The installers did not create it. They didn't touch it. They didn't alter it. They undertook no duties with respect to this uncapped gas line. Under those facts, the Michigan Supreme Court held that the installers owed no duty to the plaintiffs regarding that uncapped gas line when there was later an explosion in the house. The same thing happened here. Shaw Winkler entered the mechanical room and performed its work unrelated to the air handling unit. The unit already existed before Shaw Winkler got there. Shaw Winkler did not create the condition, did not alter the condition, did not touch the condition. So when Shaw Winkler left, that hazard still remained. Shaw Winkler entered that room and simply performed unrelated work on the opposite side of the room. Under Hill, these facts are insufficient to create a duty owed to plaintiff. Now, plaintiff's response points out or makes an argument that because Shaw Winkler entered the mechanical room to perform its work, that Shaw Winkler assumed a duty. But not only does that theory contradict the common law, but it has no limiting principle. If this court were to accept that theory, every contractor who walked into a room to perform its work would be responsible for any potential hazardous condition in that room. So a plumber who has to go into a bathroom to fix a toilet could then be held responsible for an exposed wire that's also in that bathroom. That's just not the law. Michigan law has never imposed such a sweeping duty.
Such a sweeping?
Yes, thank you. Now, the next argument that plaintiff attempts to invoke is the doctrine of retained control. Now, that doctrine does not apply here. It only applies to property owners, employers, or general contractors. And Shaw Winkler was none of those. The Lansing School District was the property owner, Chrisman was the general contractor, and Lake State Insulation was plaintiff's employer. So that doctrine is just inapplicable. But even if we can entertain it for a second, even if that doctrine did apply, plaintiff cannot meet the burden of that doctrine because Michigan law requires that there be a high degree of actual control of the work being performed. So in other words, Shaw Winkler would have had to have controlled the means, the methods, the materials, everything that Lake State was doing with respect to its work. But plaintiff has not produced an ounce of evidence to establish that Shaw Winkler exercised any control over the means or methods of Lake State's work. That evidence does not exist. And the only support that plaintiff does try to point to is testimony of Steve Bolin, which arguably plaintiff mischaracterizes, but setting that aside, it doesn't matter because that testimony is still insufficient because it's just about general safety obligations that Shaw Winkler might have had under the contract. And the law regarding retained control provides safety obligations are not sufficient. That does not constitute a high degree of actual control. And so for all of these reasons, Your Honor, plaintiff cannot establish that Shaw Winkler owes a duty. There's no affirmative act of Shaw Winkler that created or caused the hazard that the air handling unit posed. And for this reason, Shaw Winkler is entitled to summary disposition.
Thank you. Response?
Hi, Judge. Nice to see you again. All right, let's talk about evidence. I think we'll have to review some testimony. First of all, plaintiff was working as an insulation company employee for a contractor by the name of Shaw Winkler. So Shaw Winkler, the subcontractor, hired the plaintiff's employer to do work to insulate pipes that Sean Winkler put into this school. And that work is done before the installation of work is done. And that's a really key point here. Because this was a entire school renovation project, Judge. And the contract was dated in November of 18, and the injury was October of 19. So the work had been going on for over a year, and the piping was replaced in this area. What are the facts? The facts are that the plaintiff was injured in a room where Shaw Winkler was actively working. They were also working at various stages over that 11 to 13 months before the injury. The air handler unit, it's undisputed, was located in the room where the plaintiff was hurt. And there were two defects there that Shaw Winkler basically ignored. And their contractor testified that had I been alerted that there were problems, as did Chrisman's contractor, they would have put a guard on this particular unit. And in fact, we know that the unit was active because our client was injured on that day. If it was inactive, or if caution tape was put around it, that would have warned everybody that there was a problem. And that's what the Chrisman and the Shaw Winkler contractors, superintendents testified to, that when we found out about a guard missing in other areas of the project, we immediately put caution tape around it and replaced the guard. Unfortunately, they didn't do that.
So Shaw Winkler, what she's claiming is that Shaw Winkler was not the general manager. Were there multiple general managers? Is this solely the responsible of the general manager to make sure the area is safe? Or is it sort of a mutual responsibility?
Sure, we cited the Latham case, we cited the Johnson case. You can read that in the brief, Judge.
Right.
Both of those cases stand for this proposition. You can't contract your way out of a common law duty. And as long as you perform an affirmative act that increases the hazard and creates a unreasonable risk of harm, you take on a common law duty. That's the longstanding Lewerke drywall contractor case. It's been around for many, many years. So the air handler unit, which was located inside the very room where Shaw Winkler was working, and where they had done work and they had done piping work, it previously had a guard. Unfortunately, the individual who had been working there for many, many years, back to 2000, I think in 16, let me get his name for you, Judge. I think his name was Mr. Hawkins or Hankins. He testified that between 2016 and 2019, and this is sworn testimony, he never saw a guard on that particular unit that caused the injury, okay? And the Kristen folks testified that had Shaw Winkler told them that the guard was missing, they would have immediately reattached a new guard, and they would have instructed Shaw Winkler to put caution tape around the air handler. Those are the facts, Judge. Our client has been waiting 6 years to get his case to the jury. Whether or not a prior court granted a C-10 motion or not isn't before this court today. This court brought Shaw Winkler back into the case for two reasons. One, they didn't warn my client. His employer was hired by Shaw Winkler to do the installation work. So they had an affirmative duty to warn not only of a missing light bulb. We have a videotape of our client trying to replace the light bulb that was out. He couldn't see. And, you know, I know they talked about him having a coal miner's light on his helmet, and he should have, you know, activated that before you go in the room. But that doesn't solve the problem when you're working with multiple employees in a dark room with no windows. The cure is to replace the light bulb. Shaw Winkler was working in there. They didn't replace the light bulb or add a light bulb. And they also didn't alert people that they hired to do insulation work to their pipes that there was no guard on a machine that pulled our client in, and pulled his body into the machine, and he suffered really, really serious injuries. He's been off of work since 2019, Judge. So those are the two defects. The question is, who's responsible? The owner, the general contractor, and also a subcontractor under Latham and Johnson, as long as they have an affirmative duty under common law to warn people of unreasonable risks of harm. I think we all can agree that an unguarded machine revving with belts and pulleys is a dangerous condition, especially in the dark. And keep in mind, our client was injured as he was putting the light bulb in, and he didn't realize that the machine was unguarded. And in fact, Shaw Winkler's employees told them they didn't know if the machine was actually working or not. And it was working, obviously, because it was serving. Let's talk a little bit about the testimony of Shaw Winkler's employee, Steve Boland. He admitted that it was Shaw Winkler's legal duty under MIOSHA to leave any area of the workplace safe for other workers, not just his workers, any workers, especially the contractors that Shaw Winkler hired to help them with the work. Shaw Winkler did work in that room where plaintiff was hurt, before plaintiff was hurt. That's at pages 67 to 71. The contract, again, Judge, doesn't tell the story. There's still a common law duty under the working.
Under the way.
I'm sorry, let me spell it for you. It's Loweke.
Thank you.
Loki. I'm sorry if I mispronounced it. Mr. Boland also admitted that there were two defects there. There should have been a guard on the air handling unit, and there should have been a light bulb. In addition, the co-employee of the plaintiff, Andrew Mahalik, admitted that Shaw Winkler's employees were in the mechanical room right before the injury. That's Exhibit 3, Judge. Crispin's project superintendent admitted that Shaw Winkler's employees were removing and replacing old pipes in that particular room. Mike Worth also admitted, he's the Crispin project supervisor, that had he been alerted to the missing guard, he would have had it replaced and caution taped. We've already gone over Mr. Hankins' testimony. Lastly, Judge, in terms of some of the legal arguments, the Hill case is actually a case my firm handled versus Sears. And in that case, counsel's right, sister counsel's right, but it's a completely different case because it was just one contractor. That's it. In this case, we have multiple subcontractors. I know the court's well aware, and we've talked about the El-Jamali case. So I'm not going to go over that again, but under that Johnson case that is on page 11 of the brief, the court specifically held that there's nothing in our state's jurisprudence that absolves a subcontractor or anyone of liability under the common law theory of active negligence. And it reaffirmed that one person's duty to another, regardless of whether they're a subcontractor or a general contractor, by operation of law under the application of the basic rule of common law, which imposes on every person engaged in the prosecution of any undertaking an obligation to use due care or to do so and govern his or her actions so that you don't unreasonably endanger the person or property of others. I remind the court under Maiden versus Roswell 461, Commission 109-121, that we produced substantively admissible evidence to show that regardless of the contract, Shaw Winkler owed its hired contractor, which is Lake States, the employer of the plaintiff, a common law duty, especially because regardless of the contractual obligations, it doesn't extinguish or limit separately existing common law or statutory duties under these facts, Judge. They created active negligence because they worked in an area and they didn't alert the general contractor or their boss that there were two hazards, a missing light bulb and a missing guard. Those are clearly questions of fact for the trier of fact under these circumstances, Judge. Mr. Bolin, who is a Shaw Winkler employee, he confirmed that their scope of work expressly included Lake State's insulation work, that Shaw Winkler had authority to stop work on the project if it identified a hazard, and that it was responsible for job site safety for operations and for employees at Dwight Rich. And that's Exhibit 2 at page 96. And that was repeated several times by Mr. Bolin. So at minimum, Judge, our client gets to a jury against Shaw Winkler on a C10 type situation because genuine issues of material fact exist in this case. We'd ask the court to deny the release sought by Shaw Winkler, and we ask that the court not adjourn the trial date, which is currently set for October, as we've asked on many occasions before. Does the court have any questions for counsel?
No.
Thank you, Judge.
Counsel, response?
Yes, ma'am. Not going to address the adjournment issue because that's a separate motion. But there are certainly some points that I would like to address. So there were some representations made that Shaw Winkler was actively working in that room on the date that plaintiff was injured. The testimony establishes that that's not true. The work was already completed. They were on site in other areas picking up and cleaning up their work because they had installed all the pipes that they were supposed to. Brother counsel spent a lot of time talking about, they would have done this, they would have done that. That evidence is not admissible at court. It's a subsequent remedial measure and therefore it cannot be.
Okay, no, you got it, yeah.
Sorry.
They would have done that. Oh, God. But there was a lot of time, they were talking about, they would have done this, they would.
Okay, so there was some conversation about, after the fact, that they would have put a guard back on, they would have put a caution tape around it. But those things constitute subsequent remedial measures, and therefore they're not admissible at trial, and therefore not admissible here today.
Let's backtrack that. I agree with you on that. Let's backtrack to what you said and argued against what you argued, which is that Shaw Winkler was working in that room, which you've agreed, and should have and could have identified safety issues, and they did not do that, and there were at least two that were readily visible.
So under the law, Your Honor, we have to look at a duty that is separate and distinct from Shaw Winkler's duties under its contract. Any safety obligations that Shaw Winkler might have had were solely by operation of the contract. The law does not require or assert a duty that obligates someone or an entity to aid or protect another unless there is a special relationship. And there is not a special relationship in this case under the law. There is.
Wait a minute, you're the gentleman who was injured was the employee of Shaw Winkler, right?
No, Your Honor. He was the employee of Lake State Insulation, which was an independent contractor of Shaw Winkler.
Okay.
But you do not owe, or Shaw Winkler does not owe a special relationship to its independent contractor. Much like if Your Honor hired an independent contractor to redo her bathroom. You don't owe them any other independent special relationship. They're the expert.
Unless I created a risk of harm, anybody them into that risk of harm, and that's the problem.
The harm here is the unguarded air handling unit that existed before Shaw Winkler was present. This is on par to the Hill case. And Brother Counsel made a distinction that, well, this is different from Hill because Hill was just one contractor, but this case involves multiple contractors. That could be a valid argument maybe against Chrisman, the general contractor, but Shaw Winkler is not a general contractor. It only had one contractor on site. So the Hill case is still very much applicable to the facts of this case. And I also wanted to point out, the plaintiffs are relying on this Johnson case to support the position that supports their position, but it doesn't. Again, the Johnson case involved a general contractor. Shaw Winkler is not the general contractor. Johnson involved a contractor who actual work, they installed footboards or toe boards for roofing work that was done improperly, and then the contractor that came in after was injured because of that improper installation. That actual work of that contractor caused the injury. That doesn't follow here. And then the same thing with Latham. That case, the defendant was a general contractor. Again, different than from what we have here, because Shaw Winkler is not a general contractor. It doesn't have the same duties and obligations as a general contractor does. So we can't look at that case law and compare it. It is more comparable to Hill, where there was just the one contractor.
The plaintiff was an employee of Shaw Winkler's direct subcontractor, right?
Yes, plaintiff was an employee of Lake State Installation, which was an independent contractor. And generally, the case law holds that the person most responsible for their employees' injuries are the employer. Again, it's just like if I hired an independent contractor. I hire them because they're the expert. I'm trusting them to do that scope of work. I don't then owe them some other special relationship to protect them while they're doing their work. The law doesn't recognize that as a special relationship. The special relationships that the law recognizes is employer-employee, landowner invitee, common carrier and passenger. That doesn't apply here. And the only way that they can apply that here is if they were to satisfy the retained control test, which they can't because Shaw Winkler's not a general contractor. And I think with respect to the fact that there was some mention of the air handling unit being running, the entire time that Shaw Winkler was working in that room, the air handler was off. So there was no testimony that it was running while they were actively in there working. And I think those are all my rebuttal points, Your Honor. Do you have any further questions for me?
No.
Thank you.
Anyone else in response?
Because I haven't taken a position nor filed a response, but I just want to make it clear that there are discussions and allegations asserted against Sedesco Magic in this motion in response and in the motion as to the third-party complaint as well. And I just don't want it to be taken that by not responding that I'm acquiescing to any of those. And in fact, there are disputes as to some of those, but I just want to make it clear that I haven't filed a response and that is still an issue regardless.
Thank you. I am denying your motion at this time without prejudice because it does appear that there are issues of dispute, and further, it's a question of Shaw Winkler's responsibility in regard to whether or not they owed this duty. I know that defendant argues they didn't owe a duty. Plaintiff argues they did. And there's a question of the missing light bulb, the missing safety. And there are matters that are in dispute. I'm not comfortable dismissing you at this time. The question of whether Shaw Winkler owed a duty is in dispute. And I think Shaw Winkler did owe a duty to leave the area safe. I'm not sure exactly what they knew or didn't know. I know they were in and out of there. And the plaintiff was injured where Shaw Winkler was working. So I'm not granting it at this point. Doesn't mean you stay in forever, but at this point, it's denied. Do you have another issue?
I brought proposed orders, if we could take care of those maybe today.
Sure.
Of course, I left them blank, 'cause I was hoping you.
I know.
I didn't see the orders. Does it say without?
It doesn't say anything. I just put some lines so we could fill it in.
Oh, okay.
Yeah.
Clearly, as you know, I've looked in the light most favorable to the non-moving party, and I've simply said that it is hereby ordered that Shaw Winkler's motion for summary disposition and lieu of answer on plaintiff's third amendment complaint is denied for the reasons stated on the record, and there are reasonable facts in dispute, and this is without prejudice. So I think that works for today's purposes, and we'll get you all copies. Next.
Yes, yes. Next motion is, excuse me, the motion for summary disposition on the third-party complaint. This motion presents the court with 3 legal questions. The first one, whether Chrisman may pursue common law indemnification despite plaintiff alleging active negligence against Chrisman. Now, under the law, common law indemnification is available only when the party seeking the indemnification is free from active negligence. And this determination is made by looking at the plaintiff's complaint. And where the plaintiff's complaint alleges active negligence, common law indemnification is not available. In this case, plaintiff's complaint specifically alleges the active negligence of Chrisman.
Specifically what mentions?
Alleges the active negligence of Chrisman because it places Chrisman's own conduct or lack thereof directly at issue. Plaintiff specifically alleges that Chrisman failed to properly supervise, Chrisman failed to inspect, Chrisman failed to rectify the hazardous condition, and Chrisman failed to warn of the hazardous condition. Each of these theories are directed at Chrisman's own conduct and Chrisman's alleged wrongdoing. These are allegations of active negligence that preclude Chrisman's common law indemnification as a matter of law. Now, to get around this, Chrisman has attempted to characterize plaintiff's allegations as merely passive negligence, but that's just not true under the law. An example of passive negligence would be a claim under the owner's liability statute in a third-party auto case. Their liability attaches by mere ownership and by operation of law. That is what passive negligence is. That's not what we have here. And Chrisman cites to Provencal, Provencal versus Parker, for the idea that the failure to discover a pre-existing condition created by another is passive, not active negligence. But Provical does not say that. Provical simply holds that a passive tortfeasor is entitled to indemnification.
That's not reading. Does not say that.
Provical does not say that whatsoever. Provical holds that a passive tortfeasor is entitled to indemnification where the actor against whom indemnification is sought is actively negligent. So in this case, because plaintiff's complaint alleges active wrongdoing on Chrisman, they cannot pursue a claim of common law indemnification. So the answer to the first question is no. The second question that the motion presents is whether Chrisman may enforce contractual indemnity provisions in a contract that expressly states it creates no third-party beneficiary status. Now, I think for purposes of today, it seems like it's been a long day here. So the parties have thoroughly addressed the third-party beneficiary issue in their briefing. So I don't really want to spend any time on it. And I think also because the court doesn't need to decide whether Chrisman is a third-party beneficiary today, because even if we, just for purposes of argument, assume that Chrisman is entitled to that designation, the indemnification claim should still fail. Because the triggering conduct of the indemnification clause is not met. The relevant indemnification clauses that we have here are not unlimited. They do not require Shaw Winkler to indemnify Chrisman for every single incident that occurs on the project. It only applies to claims that arise out of the breach of Article 5 of the contract. Now that article required Shaw Winkler to do various things. So one, for example, cooperate with Chrisman's safety program, assist in the prevention of accidents, comply with applicable safety laws. By the plain language of the contract, Chrisman is not entitled to indemnification without first establishing that the claim arises out of one of those breach. And Chrisman has not done that. And this is a motion based on C10. Our motion was properly supported with testimony and documents. Once we filed our motion, Chrisman under 2.11624 was required to also provide this court with affidavits, testimony, documents to support its position. But after 3 years of litigation the first time around, after over a dozen depositions and having a second opportunity to respond to this motion, Chrisman still has not identified any evidence establishing that Shaw Winkler has breached the contract with the district. There are no affidavits, no transcripts, no documents attached to Chrisman's motion. And courts do not deny a moving party summary disposition simply because the non-moving party states there was no breach without any evidence. And so because of this, Chrisman has failed to meet its burden on summary disposition. And we would ask the court to grant our motion and dismiss the third-party complaint.
Thank you. Council response, are there any affidavits or supporting documents that you filed?
Your Honor, we're talking about legal arguments here, not factual arguments. When we're talking about count 1 being the contractual indemnification, count 2 being the common law indemnification, we just heard plaintiff's counsel reference testimony where had Shaw Winkler alerted Chrisman, it would have put the guard back on the air handling unit. Each time I've been at this court, I've seen how big that stack is. I didn't want to make it any bigger unnecessarily, but that is not to say that there is not countless and voluminous testimony, evidence establishing and will be repeated at trial that Shaw Winkler, not Chrisman Company, was in the best position to observe this defect. And I kind of want to zoom out here because you've been being told throughout today that Chrisman was the general contractor. That is not the case. Chrisman was the construction manager as advisor. It's stated that in the Shaw Winkler contract with the Lansing School District. And it's just important to emphasize that because this is not a typical construction arrangement where the Chrisman company would be the general contractor who then contracts with the subcontractors and is there on site every day managing. This is much more of a, think of them as kind of being in the office and managing kind of the logistics of the project, but not being on site supervising these subcontractors. Instead, and this is why Shaw Winkler has a contract with the Lansing School District that identifies Chrisman Company as the construction manager. And I'm emphasizing this because I want the court to see that the Shaw Winkler was the one in the room doing the work. They were the ones installing the pipe that had to pass by that air handling unit, that every day they were in that room, they saw that there was not a guard on that air handling unit and didn't do anything about it, did not alert Chrisman of it. And I want to read, because I think we were kind of glossing over some of these parts from the trade contract between Shaw Winkler and the Lansing School District. So under Article 5F2, it says that Shaw Winkler would take all reasonable precautions for the safety of its employees on the projects, to assist in the prevention of accidents or injury to persons on or adjacent to the premises where the work is being performed. On or adjacent to, I think we can all agree here that that air handling unit would be adjacent to the work it was being performed, right? So, and to comply with all federal, state, and local safety laws. Again, we heard reference from plaintiff's counsel that Shaw Winkler's own employee admitted in a deposition that not installing the air, or putting the guard on the air handling unit violated my OSHA. So when counsel is sitting here saying that we didn't support our response with anything, you see that stack of paper, you've seen the motions that we filed, the exhibits that we've attached. There is plenty of evidence here supporting our response, but just because we didn't attach it unnecessarily does not mean it's not in the record and in front of this court for its consideration. Another part that I wanted to direct the court under that same provision, trade contractor, meaning Shaw Winkler, further acknowledges and accepts full responsibility for safety on the site as it relates to the trade contractor's operations and employees, which would include the plaintiff here as an employee of its subcontractor, Lake State. Then under Section 5, Article 5F3, it shall be the responsibility of the trade contractor to furnish his employees a place of employment free from recognized hazards that are causing or likely to cause death or serious harm. So those are two safety provisions that are making it very clear that Shaw Winkler, not the Chrisman Company, was in the best position to observe and remedy this. And again, when I'm saying all this, this is not an admission that this was an active hazard or that, I mean, we don't believe Shaw Winkler did anything wrong, just the same way we don't think the Chrisman Company did anything wrong. But it's like, if Chrisman Company is going to be in it, Shaw Winkler needs to be in it too. Another, again, I just want to read these provisions because I think they're important. Article 5F5, the trade contractor hereby agrees to release, hold harmless, and indemnify the construction manager and the owner from and against such loss, delay, fine, remedial cost, action, or cause of action arising out of any breach in whole or in part by the trade contractor of this article. So, and another thing I should point out, we are referencing, we incorporated by reference certain exhibits from Shaw Winkler's motion. So I should have added that. Again, I didn't need to attach the same trade contract that Shaw Winkler attached. So again, the idea that there was no evidence presented in support of our position is just wrong. So here we have specific provisions outlining what Shaw Winkler's contractual duties here. We've heard reference to testimony here about how Shaw Winkler failed in its responsibilities and its contractual duties. And then we have specific contract provisions here requiring Shaw Winkler to indemnify the construction manager, the Chrisman Company, for any alleged breach of these safety standards that I've referenced and read out. So for the same reasons that you denied plaintiff's motion here is the same reason why the indemnification claims prevail or exist, continue through, and are not right for summary disposition here. And you know, we kind of brushed over this no third-party beneficiary, but I mean, that is the principal claim here. And so if you have questions about that, it almost seemed like they conceded that this third-party beneficiary claim or argument doesn't hold water. So I can go into detail of that. I mean, that was the majority of actually my response. You know, I was kind of surprised that this argument was made because, you know, we have 5 different operative provisions here where the Chrisman company is named in this contract, and then they're trying to say that Chrisman was not intended to be a third-party beneficiary of that contract. It kind of doesn't make any sense. I don't know if these are law students here. I'm sure that if they just finished their 1L year in their contracts class, they would have been told that this is a foundational principle of contract law where if a specific provision and a general provision conflict, the more specific provision prevails. So, I mean, it's really foundational stuff. You know, I'm not making any wild and crazy arguments here, but that's kind of my stance, and I don't want to get repetitive on the count 1, which is the contractual indemnification claim. But going back to the common law indemnification claim, when we're talking about active versus derivative liability here, the conduct described, which is failure to supervise, failure to alert, failure to do things, that is derivative liability. It's not active liability. And that is exactly what common law indemnification are. So just trying to transform, because specific conduct is identified as being attributed to Chrisman, does not transform it into active negligence. Here, a failure to notice the unguarded air handling unit is not active negligence or active liability, it's derivative liability. Again, we're talking about really foundational stuff here. You know, I'm not making wild and crazy arguments here. The cases that we've cited, everything that we've put in our briefs, you know, I think it is pretty standard. So unless Your Honor has any questions for me, I think that's our position here. Thank you, Your Honor.
Briefly, Your Honor.
Yeah, can you address the derivative or passive issue?
Yeah, so this plaintiff's claims are not a derivative claim. A derivative claim is something like a loss of consortium claim. Like, so in other words, that claim cannot survive unless, so as a husband and wife will say, the husband was injured. The wife's loss of consortium claim cannot survive unless the husband's claim also survives. That's what a derivative claim is. It's essentially reliant on another claim. That's not what plaintiff's claims are. Plaintiff has expressly alleged the negligence of.
Plaintiff has expressly
alleged the negligence of Chrisman. Plaintiff has expressly alleged premises liability claims. The failure to act, just because it's a failure to act, does not mean that it's passive under the law. It's an active negligence claim. That argument does not hold any water, and they haven't cited any case law that actually supports that position. As I had mentioned in my first argument, the Provencal case that they cited does not hold what they cited it for. In that case, discussed passive negligence being respondeat superior or the owner's liability statute for a third-party auto case, where you are liable by operation of law simply because you own the car. So respectfully, plaintiff's claims against Chrisman are not the same as a derivative or passive negligence. And so I think that claim is ripe for dismissal. And some other points that were made about the lack of evidence attached to Chrisman's motion. Sure, they cited to the complaint, but as I had said in my first argument, just saying that a contract was breached doesn't make it so. And he kept referring to plaintiff's testimony, the testimony that plaintiff produced. Well, that was that different motion that plaintiff did attach to their motion. And just because there might be other evidence in the file, Chrisman was to put up or shut up today, not weeks ago or in the future. Today was the day that they were supposed to provide this court with evidence establishing their claims, and they have not done that. And I also want to point out this whole construction manager as advisor thing. That's a distinction without any meaning. They haven't established or explained how that is any different from a general contractor, when the contract specifically required Crispin to be on site and do and inspect things and have safety meetings and those sorts of things. So I don't think that that distinction has any significant weight here. And again, in rebuttal to my argument, Crispin stated that they don't think Shaw Winkler did anything wrong. So how could we have breached the contract? And again, I just think that their motion does not meet the burden that they were supposed to meet today, and therefore their claims should be dismissed. Does Your Honor have any questions?
No.
Thank you.
They were made genuine issue of material fact regarding whether Crispin or Shaw Winkler breached their contractual safety coordination and duties, who's the general contractor, what does it all mean? Failure to act is an act, and there's also disputes as to whether this target passive derivative liability, well, I understand what Shaw Winkler is saying in regard to the derivative liability. There are supervisory failures, and so again, there are common law and implied indemnity theories that are here, but they're in dispute, and there's just simply genuine issues of material fact, whether this is a C10 or whatever you want to call it. I can look at a couple of these under the summary disposition court rules, and it fails. Your arguments fail, so I'm denying this as well, at least for today, without prejudice. Next issue.
Yes, Your Honor, I also have an order for you on that.
You may approach. Next issue.
The next is Shaw Winkler's motion for adjournment of the scheduling order dates. I know the court has been clear on its intent to keep the parties on a fast track, but the court has also been clear that it's not going to require parties to, forego their rights and their duties in properly building their defense of this case. At this point, Shaw Winkler has acted diligently in obtaining the file materials from all the counsel for the last 3 years. But receiving another's file is not the same thing as conducting discovery. Yes, we received medical records from plaintiff's counsel, but Shaw Winkler is also entitled to receive those from the source.
Hold on, we're gonna lose Zoom.
Oh, gotcha. Thanks, Nancy.
Sorry about that.
That was a good catch.
Thank you. I didn't look at the script and focus on her, didn't even look at the screen.
What a good catch.
Yeah, thank you.
I just saw it. It says, yes, we've received medical records from plaintiff's counsel.
But Shaw Winkler is entitled to obtain those records from the source and ensure that it has a full copy of medical records, retain good quality experts. It's been difficult to try to find experts that are able to step in and work on this tight timeline and even allow them the time to review all the file materials, conduct IMEs. The parties were working on scheduling a site inspection, but I need to get an expert to show up there, and it's been difficult with this tight timeline. And so the current schedule just makes the meaningful discovery and the exercise of Shaw Winkler's rights to fairly and properly defend its case.
So let me just start with this. Have you identified experts? Have you tried to set up meetings? What time frame are the experts telling you?
So I have two experts lined up. There's two other ones that we still haven't heard back from. One of them is able to get an IME potentially in July. I haven't checked my email since I've been here. But the other ones are still all up in the air, and it's just, are they gonna be able to get it done? Are they not going to be able to get it done? I mean, there's others who have just flat out said, we can't help you with that timeline. And so the expert pool, you know, that obviously shrinks the expert pool.
So what kind of timeline are you looking at?
In our motion, we requested at least 90 days. That would still allow plaintiff to have his day in court before the end of the year.
Are you looking at December?
I think that's about the 90-day timeline, yeah.
Response, I know everybody wants it to not be delayed, but in all fairness, I've kept them in. They get to do their due diligence, we all have licenses to protect, and we want to do a meaningful trials. Plaintiff has waited 6 years. I don't know that 2 months more or less is going to make a difference. I can do it in December.
Judge, I would propose that we, I'll step up. Again, John, it's for the plaintiff. I would propose that because Shaw Winkler and Crispin have been back in for a couple of months now, they haven't really identified a particular witness they want to depose, except maybe one expert. Site inspection can occur. I mean, we don't control the site.
Okay, so site inspection granted, she can work that, you all can work that out. She's got 1 or 2 IMEs, but then there's another couple and she's waiting, and I mean, we all know the problem. I have this on my docket too, nobody wants to work in July, including me.
I agree, Judge.
We're all on vacation. And
I
if
wish.
not, you're going downstairs to divorce court, right?
Something like that. but
Something like that.
We've got 2 trials in July, so.
Yeah, well, we all gotta have a vacation. In Michigan, the summer's getting shorter and shorter, so doctors like lawyers, it's the same thing. Try getting a doctor's appointment in July. It's not happening, or even August. So I don't fault them. At least she's trying. When I asked her, she's been working on it. She, I think, anticipated what I'm gonna do, and they're working on it. So I can't, how do I deny counsel who I've just let back in despite everybody else's work? You're asking her to rely on your work. No offense, I'm sure it's fantastic, but would you rely on her work? No offense to anybody. No, you wouldn't, because we all have our own licenses to protect. So
Sure.
trial's gonna be December 4th.
Okay, Judge, I was gonna ask you for a date certain.
There it is. I'll probably have to move some criminal that I promised, but I don't know. Well, this begins Hanukkah. Is that gonna be a problem for anybody?
Not for plaintiff.
No, you're on.
All right, if it is, we'll just start at the 7th, but I think Friday, December 4th is what we're gonna do.
Okay, and Judge, as far as discovery cutoff, can we have a firm date where discovery is ended?
Right now, discovery is open until July 15.
Mhm.
I think maybe if we want to, do we want to extend that?
Yes.
How much time do you need?
I think it would be nice if we had discovery through whatever new facilitation date you set.
I don't have that.
How about August
That's
15th?
August.
How about August 15th, Judge?
Yeah.
For discovery cutoff.
I think that's the current facilitation, remediation must occur by August 15th. Is that right, Mr. Eads?
Yeah. Yeah, so we could leave discovery open.
Are you
until
gonna be able to
facilitation.
get everything done by then?
I think discovery through October would be more ideal.
Well, that doesn't leave much time to get ready for a trial judge, with all due respect. I mean, Mr. Stockford doesn't work. He'll go to any IME they want him to go to. But
The beginning of October leaves 2 months.
how about the end of August?
How about September 30th? There you go.
Okay, Judge, thank you.
Do we want to change the facilitation? must-
Facilitation will be done by Halloween. Don't make me be a goblin.
Not on Halloween, please.
No, just by Halloween. Halloween's the 31st, so before the 30th. On or before the 30th. I suspect you're gonna need a couple of days. If I was the mediator, I'd probably need a few days, so we'll schedule it on the last day. By Halloween. Pull off that trick or I'll be no treat.
So we'll get that put in writing right now,
Great,
all right?
I have a proposed order for that one too.
great.
And best of luck to your law students.
Yeah, I hope this didn't.
Let's hope
dissuade
after
you from
watching this, they
litigation.
still wanna practice law. What would you like?
It's always hard.
Oh, sorry, I couldn't write down where you
Stuff,
were.
yeah.
That's something, you know, Wayne County.
So
is a
we're adjourned
separate
to-
criminal court. You don't have to worry about that.
Trial December 4th. Discovery September 30th. Discovery through September 30th.
I'm sorry.
And then facilitation.
You say, mediation.
Yes, right.
We're making you do a lot of work today, Your Honor.
This is easy.
I've seen that.
All right, and then do we want to have a pretrial somewhere between October and December, like November or something? Going to have a pretrial just to go over court rules and, jury instructions and all that?
I think that'd be good.
Yes, Your Honor.
Okay.
Judge, is that when you want the final, joint final pretrial order?
Yes, and jury instructions to see where we're at with all that. So
Okay.
you all are smart enough to figure that out. So let's do, November 18th at 1. Anything else we need to?
I would like to raise one issue since we're all here together.
Yes.
Based on the rulings today, Shaw Winkler is probably going to proceed, not probably, will be proceeding with appeals. And so
Have fun.
I'm going to make an oral motion for stay of proceedings because I have to present it here
Okay.
under the court rule before.
So your stay is denied?
Okay, I have an order for that too.
I just put it in here. Stay is denied,
Like it, but you
and that way
You're gonna put it in
you
that.
can move this to Court of Appeals.
Okay.
Yeah, I just put it in here. I can do it a separate one if you want, but
Whatever the court
it's
prefers.
okay. I just made it simple.
Okay.
All right. Happy to hear from the Court of Appeals.
If you ever hear from them.
Yeah.
Yeah, before my retirement, right?
Yeah, jeez.
All right.
That's not anytime soon.
No, I've got 6 more years left. So we'll see. But they're not good up there, so who knows?
Do you know Judge Anderson? She-
Yeah, they need to change the age requirements,
Yeah,
but
be the judge Breck opinion, right? I think he's.
all right, thank you, that is all. Good luck, thank you for your time, your arguments, and all the trees you killed.
Enjoy your July.
Yes, you too, thank you.
Thank you.
Thank you.
See you, Tim.
See y'all, thank you.
To you folks.
Oh, guys, I'll get you your copy.
Oh, thanks. Sorry about that.
There's a Dana Nessel.
Judge signed it.
Versus
Two,
complete
right.
health department.
Yeah.
Nancy. We're doing hers. I guess so, I was just handed it, I don't know.
Sure.
I'm just gonna copyright myself.
What if I say that you guys?
Yeah, this is a body.
Doesn't help.
You think you're great,
Huh?
show up. I feel the same way.
I know.
Have a good one, guys.
Yeah, thanks, Brian. Thank you, Your Honor.
Thank you, have a good day. All right, this is docket 26, 853 CK, people in the state of Michigan versus Complete Health Park. Council, anybody here? This is Dana Nessel, Attorney General of the state of Michigan, XL, people of the state of Michigan versus Complete Health Park. No, nobody's here. Is a motion for default judgment?
Yep.
Well, no one's here. Looks like everything is in order for the court to sign it, but I don't know that I have the default, I have the summons. And I don't have a proposed order, so I guess when they provide me with one, we'll deal with this. Meanwhile, I called it, no one's here. We're on the next case. Okay, hold on. To possibly figure out where they were. Okay.
The next default, that's in versus Brooks Johnson, I'll say.
Okay.
Yes, I'm ready.
Okay, this is docket 25, 5396 NI. Elena Hudson versus Marcus Brooks, Tamika Johnson, Allstate Insurance Company, Farm Bureau General Insurance Company. Counsel, your appearances for the record.
Good afternoon, Your Honor. David Safran on behalf of the plaintiff.
It does not appear that anyone on behalf of defendant is here. They're not on Zoom, and no one's in the courtroom. Doesn't appear that anyone has called. You were asking for entry of default judgment.
That's correct.
And I don't recall if you gave me a proposed order. If not, please approach with one. I see you have a number of attachments, but I don't recall if there was one. I think it's just showing it the service.
Okay, I'm sorry.
It's okay.
I think there was one provided,
Well,
but if you're not showing it.
I have, well, and it may be that I just looked at the default, so let me just see if it's tucked behind here, and I didn't get that far. Supporting motion.
All right, just provide one if that's
Do you
okay.
have one?
Yes.
Yeah, I have like everything else, it's just unless I breeze through it because of all the documentation you provided, but looks like you certainly complied with the law and all the notice requirements, so. I am happy to sign this,
I don't have amounts filled in yet because I don't know what will be ordered, obviously.
council, did you plead a specific amount, or is there, or do we need to have a hearing on a specific amount?
I believe we need to present proofs because it's a personal injury case.
Yeah, so we need to just set this for an evidentiary hearing? Or-
My client's here, we can do
Okay.
testimony today. I'm
Okay.
ready to do that.
Ma'am, please come up here. Please raise your right hand. Do you swear or affirm the testimony you're about to provide will be the truth, whole truth, and nothing but the truth and the penalty of perjury?
Yes.
Thank you. Put your hand down, have a seat. Feel free to adjust the microphone so you can, it's bendable, so you can speak into it clearly. And then please state and spell your name for the record.
Aquilina Hudson.
It's okay. Like, wow. All right.
Aquilina Hudson, first name spelled Elaina, last name Hudson, Hudson.
Thank you. You're the plaintiff in this matter.
Yes, ma'am.
And you're here to testify now. There's a default. It looks like no one on the other side has shown. This was scheduled, it looks like, what was it, scheduled for 1:30?
2 o'clock.
2 o'clock, and it is now 4:52. Court has waited sufficient time, so we're going to hear information from you in regard to what the amount of damages is. All right? Counsel, you may proceed.
Thank you. Judge, this is a preliminary matter. I know the proofs were attached to the motion. If you're interested, I do have a copy of the police report and a couple of pages of medical records or.
It's up to you if, do those have amounts? I mean, you've pled those issues, so.
Okay,
Yeah.
that's okay. Okay. Ma'am, you've already stated your name for the record. Did you bring the present lawsuit as a result of a motor vehicle accident?
Correct, yes.
And that occurred on November 8th of 2024?
Yes.
Your Honor, may I leave? I forgot to ask.
Huh?
May I
Oh,
leave?
yeah, absolutely.
Okay. And that was a rear-end accident, is that correct?
Correct, yes.
Did you sustain injuries in that accident?
Yes, correct.
And what injuries did you sustain?
It will be my lower back, the front of my chest, and my neck.
Did an ambulance come to the scene?
Yes, they did.
Were you treated by EMTs at the scene?
Yes, they did.
And you were taken to emergency room at Sparrow? correct?
Yes.
Do you remember what kind of treatment they were under?
Let's see, x-rays, blood pressure. So far, that's what I think of.
Did you receive any follow-up treatment?
I did.
And who was that with?
That was with my primary care doctor.
Did you also have physical therapy?
I did.
And how long did that go on for?
About 8 to 12 weeks.
Okay, did you miss any work as a result of this accident?
I did.
And then after returning to work, were there any special accommodations that had to be made for you to do your job?
Correct, yes.
And what were those accommodations?
So what I was doing was being a cashier, and my position was just folding clothes up to getting the big boxes, so I was not able to bend over to pick up any of the big boxes. So I now, after, I just had to be behind a register and just, do the cash register.
Were you disabled from performing normal household chores?
Yes.
Did you also require assistance with personal care such as bathing and things like that?
Correct, yes.
How long did that care go on for?
About 4 months.
Were you given any type of medical appliances as a result?
Yes.
And what were you given?
A back brace.
Who was that prescribed by?
My primary care doctor.
Do you still use that?
I do, yes.
Okay, does that mean you still have symptoms?
Yes.
To this date?
Yes, with my lower back.
Your Honor, I don't have any further questions at this point.
And counsel, do you have a breakdown of what it cost or what the co-pays were for the ambulance or the hospital stay, if she lost any work, how much, and the medical appliances, prescriptions, all of that?
There's no fault in this. There's also a no fault component of this case, which I think is still pending. So those would all be first party benefits. So just given clear liability and with symptoms lasting over 1.5 years and still going on, I would request a judgment and the amount of $50,000 as to each of the two defendants.
And the other defendant would be,
Marcus Brooks was the driver and Tamika Johnson was the owner of the full vehicle.
so $50,000 each.
Yes, please.
Ma'am, do you believe that that is fair?
Yes,
And out of that, you'll be paying the expenses and any claims as well as your attorney's share?
yes,
And Marcus Brooks, is he an adult or child or
pretty sure he's an adult.
were you with
Over the age
him?
of 18, no.
Okay, so
Your Honor, if I may, he's listed on the police report. At the time of the incident, he was 19 years old. He'll be 21 in about another month and a half.
and you're representing both of them?
No, those are the defendants, Your Honor.
I'm sorry. Oh, okay, oh, I got you. Okay, so is going against the insurance company and both Marcus and Tamika individually?
This is just going after Marcus and Tamika individually. The insurance company is a separate case, and that's at issue. It's a separate claim, I should say.
Okay, so the monies that you are getting from the insurance companies, there's Allstate and Farm Bureau, those would be separate and apart from this because you're only entitled to one judgment, right?
Those are separate and apart. Those are for first party and LFL benefits only, and this is, the claims against these two defendants are for third party, not economic damages.
Okay, just want to be clear on the breakdown. All right, you would agree with that, ma'am?
Yes,
All right, and so, again, it's 50,000 against each of them or both of them? So they're 50 and 50 or just 50?
I'm asking for 15, a total of 100.
Okay. And on this form, you have plus statutory interest and costs. Is there anything additional you're asking, or does that encompass everything?
That encompasses everything.
All right. Here's the carry order. You should see copies in just a moment. How many copies do you need?
If we can get 3, that would be great.
All right, thank you.
Thank you, Your Honor.
Probably not going to in the hall. All right, this is docket 18-820 CE. Michigan Department of Environmental Quality versus Demolition Contractors, Inc. Counsel, your appearance for the record.
Teresa Hendrickson, Demolition Contractors.
Andrew Prinz, Assistant Attorney General here on behalf of the Department of Environmental Quality.
All right, thank you. And counsel, this is your motion.
Well, actually, it's our objection, Your Honor.
Your objection, that's fine. Counsel, you may proceed.
Thank you, Your Honor. Good afternoon, Your Honor. We really shouldn't be here today. A hearing was held on May 5th with regard to an award of attorney fees. The defendant demolition contractor served their proposed order on May 6th. We filed objections to the proposed order. Thereafter, demolition contractors filed a response that included a revised proposed order on May 26th. So they attached a revised proposed order that they asked this court to enter. We contacted them and offered to stipulate to it for entry. We did not get agreement to it. The next day.
But wait a minute, was their order?
There was a proposed order that they filed.
Yes.
And we offered to stipulate to it.
Okay.
We then made a copy of the order, sent it to the other side, and I asked whether I could sign for her and submit it. No agreement to do that. So then this past Friday, we filed a stipulation, or a reply and a stipulation whereby we agree to this court entering that revised order that was filed on May 26th. It's pretty straightforward. This is a waste of time. They proposed an order and asked this court to enter it. We agreed to enter it, and then we filed a stipulation that we agreed to its entry by this court. And as I said, ultimately, it's accurate, and it comports with the court's decision. And we've moved that it be entered. I know that demolition contractors has filed a motion. I got it this past Friday at 5:30. There was no notice of hearing. It was not filed in order to be timely heard today, and we'd object to it being heard. But if this court wants to entertain that motion, which addresses adding things that determinations that were not made at the May 5th hearing, we would like to address that. But otherwise, we believe that the order that was filed May 26th with their response should be entered, their revised proposed order. Thank you, Your Honor.
Thank you. Response?
Your Honor, just a correction for the record. We proposed the first order. DEQ objected to a number of things in that order. And so we proposed differences in it, and we had to wait for them to get high level approval. I proposed a second order, and they filed an objection. When their reply came, well, and I filed a response. And the response was extremely important because DEQ was trying to gloss over and ignore an agreement that they had made on the record under Judge Jamo, that they had waived a hearing under Smith. They waived cross-examination of counsel, they waived the witnesses. And so in my response, I alluded to those things. I provided the transcript, and specifically, Mr. Kearns on behalf of DEQ said, we intend this to be a walkthrough for the fees. It's a walkthrough, no witnesses. At the time of my motion for fees, I didn't schedule it as an evidentiary hearing because we had an understanding that there wasn't going to be a Smith-style evidentiary hearing. And in fact, I didn't have the record before me from 2 years before where he put on the record his agreement to waive a hearing, an evidentiary hearing on fees. One of the things he wanted changed in the order, he wanted it to say that He didn't want it to imply that the court held a Smith hearing. So I agreed with that. No Smith hearing was held. But he wanted it to imply that the court didn't consider the Smith factors that were in the brief. So we corrected that language. Right now, DEQ wants language in that order which says that the Smith hearing was not heard, which we don't have a problem with, but they don't want any language in there that says that they waived a hearing on the fees on May 3rd, 2025, which I put in my response. I put the
I
transcript.
think you both did, because I remember doing the math and not liking math, because I don't like math. And isn't this when I was listening to both of you and doing all of that, and then it looks like you both have the same number. So is this just a question about whether you both waived the Smith versus Corey hearing? I mean, I think it's the time I said this was the time for Smith versus Corey, but there was no expert, there was no nothing.
That's exactly the issue. We just want to add to the order that we agree on that we waived the Smith v. Curry hearing. What I was referring to was a May 3rd date under Judge Jamel, but they also did waive it before, Your Honor. We both did.
Right, because it was set for Smith versus Corey and nobody had the requisite documents or the experts, so we just proceeded, which by proceeding, instead of preserving it and saying we changed our mind or whatever, you proceeded. So you both waived as far as I'm concerned.
Your Honor, we did not waive it.
Well, did you want one?
We wanted a Smith versus Curry hearing.
Well, did
We
you-
asked for one.
Did you bring a hearing?
What's that? We asked for one.
I mean, so did you bring an expert? When you have a Smith versus Corey, you have to have the state bar with what they publish every 2 years, right? Under Smith versus Corey, you have to have that. You also have to have an expert present that talks about the time the expert is needed and what was relevant to and not for the services that were provided. And we have to take testimony, and there's a whole lot of different moving parts. Over the years, I've had them. They're long, and you can't just show up and say, we're ready for one without any documentation or experts. So we proceeded. To me, that's a waiver.
Your Honor, we did not waive the Smith hearing. The procedure was set up where we were to appear before you. There was a stipulation where the parties agreed to file the claims, and then we were able to file objections and then have those objections heard before you.
Okay.
Now, with respect to those objections, our objection was to the reasonableness of the hours. And we requested that they be ordered to either revise their numbers in order to provide us more information, or we get the Smith evidentiary hearing. We requested that specifically on the record on May 5th. And I stood up in the middle of the hearing and I said, you know what, Judge, you're right. We need a Smith hearing because we have a dispute that we're not going to come to an agreement to on the objections. So, I mean, at that point, we did not waive the Smith evidentiary hearing. We made our objections, and we said that ultimately that we want a Smith hearing if we don't get the accurate information.
So what are you telling me? Because you just said that you sent them something that you stipulated. So did you not tell them the truth that they're stipulating to these numbers, or what?
The numbers aren't the issue. The numbers are that they waived the Smith v. Curry hearing in May of 2022 and on the 5th.
But they're saying now they want a Smith versus Corey, but you said a moment ago you were stipulating to these numbers. You can't have it both ways, sir. Smith versus Corey means the numbers could go up, they could go down. Are you agreeing to these numbers?
We don't agree to the numbers. We seek to appeal them. We have the right to appeal them.
You do have the right to appeal them, but when you were here, we had agreement, I thought, or I would have said, let's do the hearing, and I can go back and we can look at the docketing, but this was scheduled for a Smith versus Corey hearing that no one was prepared for.
Well, it wasn't. It was scheduled for objections that the court was to hear, and our objection was, you know, can you please order the other side to provide more detailed information, which I think is reasonable. I think if they're not providing detailed information, that it was reasonable to ask for more detailed information before going and having a full Smith hearing. I think that was a reasonable approach, and has been done in other cases, but we never waived our right to a Smith hearing.
So if I go back and read Judge Damo's transcript, which I hate that we did this big switcheroo, because we've all got cases that we didn't hear all the testimony to, and it's a lot of extra work, but if I go through and listen to Judge Jamo's transcript and read it, did you both waive a Smith versus Curry hearing in front of him?
We did.
No, Your Honor. I think at that point, we were asked to submit our claims for attorney fees. So we had to figure out an evidentiary way to do it. So we were either going to have to give our own testimony or submit affidavits and documentation. And that's what we agreed to. It was a process for submitting the claims where we agreed to submit it through affidavits and documentation. As far as like, and at that point, what was at issue was number one, whether he would award attorney fees. And we argued, number one, that we should follow the American rule and not award them. Or if he was going to award them, that we each should be awarded attorney fees for the claims we prevailed on. So we didn't have an evidentiary objection at that point to ask for a Smith hearing. We didn't have any objections to what they submitted at that point. We just had the general arguments that the American rule should be followed, or we should each get attorney fees for the claims we prevailed on. We didn't have an objection at that time that would require a Smith hearing. So we were okay with, and we agreed to make our claims on the record with affidavits and documentation. But we never waived the Smith hearing back in front of Judge Jamo. We just didn't have the type of objection that required a Smith hearing.
And are you looking for the transcript? I don't have it in front of me. Do you have the transcript from Judge Jamo?
I do. I can quote it.
Thank you.
On page, this is the transcript from May 3rd, 2024. Who's speaking here? I'm speaking and it said, I say there is no legal authority for an offset. The statute is clear. It is not even close to a guess that this should apply in this case. Now, the reasonableness of attorney's fees, that is considered under the case of Smith, and that is in our brief. And that talks about how you determine what a reasonable attorney fee is. Mr. Prinz and I agreed to exchange affidavits in our records so that we don't have to take testimony on that. Those could be admitted as we submitted them. My affidavit for attorney's fees and hours is our Exhibit H, and then I had a co-counsel for trial, and his is Exhibit I. If you add our hours together, we had, and it goes on, I don't have the second page, it goes on to say how close we were in our total number of hours.
And I think that's what was then argued in front of me, which is where we had the less $4,634.26.
Yes, and I have another page of Judge Jamo's transcript.
Okay.
And I say, the judge says, ask about the attorney's fees issue. And I say, yes, my presentation will cover the necessity of attorney's fees, but the actual presentation of the affidavits and requests for attorney's fees, I thought we would do that separately through written documents that we submitted without testimony. The judge says, okay. And then I say the attorney's fees should be at the end, and it should be by our paper submissions. We agreed that we wouldn't call each other to cross-examine each other on fees. Mr. Prinz replies, right. That's why it can wait until the end. Later, Mr. Prinz says, the court asked Mr. Prinz, and then the courts got to go over the Smith factors. This is on page 257. So, I mean, I think there has to be some presentation of evidence of the hours and the cost of litigation and such. That's what Mr. Prinz says. The court says, so you're intending to walk through those, Mr. Prinz? It's a walkthrough, no witnesses. So what he did at the end of that evidentiary hearing is he walked through all of the Smith v. Curry factors. We both did.
Your Honor.
In front of Judge Jamo.
Yes.
And
Right.
then, just a minute, I'll get to you, sir. And then when you were in front of me, you both presented numbers that were in dispute, right? That's how we ended up with this equation.
Right.
You both have the same numbers of.
As Mr. Prinz said, the procedure we had agreed to was we would file our briefs, they would file objections, and we would file replies, and it would be decided on the papers. And that's the way consistent with how we presented that day. We didn't have any witnesses. We didn't have witness lists exchanged. All of our arguments were on paper. And we agreed to have the judge determine that. Now in federal court, that's the way it's done. I know that's not the way state court works.
Right, but then when you ended up coming here, you had some disputes and I made the decision. Is that right? Didn't I do some math and that's why we?
Yes.
Yes. And
Yeah,
that's how-
we waived the full
Yes.
hearing and accepted your
Right.
decision. And then you said it's ready for the Court of Appeals.
Your Honor, we agreed to make our submissions,
Yes.
our claims for attorney fees via affidavits, via paper.
Yes.
But we never waived our right to have our objections resolved, to waive our right to have our objections resolved via an evidentiary hearing. We made, in our objection to their fees, we asked for either they revise them or we get the evidentiary hearing. We never waived it. And when we go back to the same thing with Judge Jamo, you know, we're talking about submission of claims, submission of fees, not resolution of objections, which entitle you under Smith to an evidentiary hearing. And I think the simple way to look at this is on May 5th, the court made numerous orders, and it awarded fees.
Yes.
It did not make any determination on whether either of us had waived a Smith hearing. There was no order, no ruling, no determination. So the orders got to be accurate and comport with the court's ruling on May 5th. There was no ruling about waiver. So it's not relevant to this order. It shouldn't be in this order because it's stating a determination that wasn't made on May 5th. And moreover, I mean, we did not waive it back in front of Judge Jamo. There was a new submission in 2026, a new claim. So I would say that the one in front of Judge Jamo was the first claim, then we have a second claim, and we don't have waiver from the first to the second claim. But ultimately, on May 26th, they filed a proposed order. And they filed it with a response, and yes, they addressed waiver in the response, but they did not include any language regarding waiver in their proposed order. And we looked at their proposed order and we said, you know what, it's fine. It accurately represents what the court ruled. And we offered to stipulate it to entry. And then we filed a stipulation with this court this past Friday, agreeing to approving its form as to entry and ask this court to enter that order. And that's what we'd ask this court to do now. I mean, it's hard for a party to propose an order, ask the judge to admit to enter it, and then walk back and say, no, we don't want that order that we wrote, we drafted, and ask this court to enter it, to be entered.
The one that you are objecting to says, this matter having come before the court on defendants demolition contractors Inc.'s motion for consideration and clarification relative to pending order and for finding that any separate evidentiary Smith versus Coring hearing was waived. That's the one you're objecting to.
We object to that motion because it's not timely to be heard today. And there was no notice of hearing for it.
I haven't noticed that motion because I think today we'll take care of that if we just add that we waived the Curry hearing. That's what
Right,
we need
because
to do.
they're asking you to address what they want in this motion without even having a notice of hearing and giving us an opportunity to respond to it.
No, this is based on the record that he created with Judge Jamo and the way we approached. He never had a motion for an evidentiary hearing under Smith Curry. All he filed was a fee information. I had the motion. I didn't schedule it as a Smith v. Curry because we had waived it. It was just scheduled as a motion.
Today is objections to this order. That's what's said.
Yes.
Okay, so the question is, does the order comply with the orders of this court? And here's what I'm going to do. And then you can entertain the Court of Appeals with me. I don't care what they do. What I care about is getting it right here, and then they can see it as they want to. But when you were here last, I believe, and I can be really
I
wrong.
didn't hear that. When you were here last, what?
I believe, but I can be wrong. I was under the impression that we were having a Smith versus Corey hearing. However, then I was advised that it was just really numbers that you were relying on your briefs, and so we proceeded. I am well versed in Smith versus Corey after 22 years, having had many of them, including teaching Smith versus Corey. When you don't show up and you're supposed to be prepared for Smith versus Corey, and that's the time I gave you, I assume that you waived it and you were all happy with the numbers. So here's what I'm going to do. I'm going to mess up your beautifully crafted document and add my own language in here.
I have a copy of one you can mess up and if you need a different one.
It's okay, we're gonna enter it as is today.
John, I'm gonna ask which order is being entered?
Well, I believe, I'll give it to you. I believe it's the one, because I'm modifying it anyway. It's the one that was submitted that I have in front of me. You may, Brian, give them each a copy of this. And then I'll tell you how I'm amending it. Okay, I have amended the first paragraph to read as follows. You don't have to like it. It's going to the Court of Appeals if either one of you are happy, but I'm done with this. I am confused as to the unhappiness today when we worked on the numbers. And I listened to both of you, so, and there was no experts or other documentation per Smith versus Corey. So it now reads as follows. The matter having come before the court on defendant Demolition Contractors, Inc.'s motion for consideration and clarification relative to pending order and for finding that any separate evidentiary Smith versus Corey hearing was waived, neither party having been prepared with witnesses as per the requirements of Smith versus Corey, having reviewed the record, and after hearing the various arguments of counsel regarding said sums being requested, and further after reviewing the May 3rd, 2024 damages hearing transcript the parties' fee submissions, affidavits, billing records, briefings, objections, replies, and the May 5th, 2026 hearing transcript, the court having heard argument and the court being otherwise fully advised in the premises. So I can put, despite plaintiff objecting, it's hereby ordered, if you would like.
Your Honor, I'm sure that's in the record.
It is in the record, so I've just clarified what we've done here. And this is an order, the amounts are there. Have fun going to the Court of Appeals. I'm not granting a stay. Would you like me to put that in here? Are you requesting a stay?
Not at this time.
Okay, well, if you would like to formally request one, you may, but for argument's sake, I don't think this should be delayed any longer. This is a 2018 case. If you want to stay, you'll have to go to the Court of Appeals. I'm anticipating a request for a stay if you're going to go to the Court of Appeals, and that is denied. So you are free to go to the Court of Appeals tomorrow if you wish. You'll each receive copies of this unless you want me to clarify the language even further.
I would just clarify I would just take off this title, because this was a motion that we didn't hear. And I would just call it order after hearing.
Okay, that's fine. Order. Sure.
And then under this matter having come before it on demolition contractor's motion for consideration and clarification, you could just change that to the objection. Motion on the objection.
This would be after hearing plaintiff's objection, correct? Because you're not objecting.
Correct.
You can show it to them first. Make copies.
Thank you, Your Honor.
Thank you, Your Honor.
Thank you.
Thank you all for staying late. Thank you all for staying late.
Oh, I didn't even know. Oh, yes, it's 5:30. My kids are emailing me or texting me for rides. They seem to forget that I work. Okay. Let me put in there. Oh.